Recording has begun.
All right, let's, whenever you're ready, let's get this one started.
Good evening. This is the May 20, 2025 regular meeting of the Complaint Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 5:33 p.m.
Starts video.
Victor, audio's on, recording's on.
I don't see the recording has started. Oh yeah, it's in progress. Sorry. It's
Thank
recording.
you.
Thank you.
No, thank you for checking. The meeting started at 5:33 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair Schmidt, that completes my announcements.
All right, let's move right into number one, please.
I do have two requests following the announcements. We have a request on item 7, file number 25030. If there's an opportunity for that matter to be heard early in the agenda to allow for staff to return to family caretaking duties, that would be appreciated. Regarding item number 8, file 25031, petitioner is unable to attend this meeting. That communication was received less than 5 days before tonight. Okay, item 1.
Just one moment. Number 8, petitioner is not going to appear, you said. And number 7, there's a request by the PUC for them to be moved up in the line.
That's correct. But
Okay.
as I look at the agenda, I should have mentioned those things at item 1.
Yeah.
Any agenda changes? Shall I call item 1?
Yeah, go ahead.
I apologize for that. Item 1, call to order, roll call, and agenda changes.
So, yeah, those that you listed, 7 and 8, it sounds like we'll just say when we get to 8, we'll deal with it. How about that? And then 7 is 4th out of 6, and they're asking for. Well, I'll just say I'm not inclined to move them up to the front. I don't have any doubts about the honesty or legitimacy of the request. There are requests that I would feel would maybe need to be moved up. But we intend to go fast here anyways. This is just a committee meeting. This is not a full task force meeting. And we're all about going fast here. So the request is made. Member Sugarman, do you feel any different about moving that to higher up in the calendar?
Shall I call roll call?
Yeah.
Oh, yeah, let's do that.
Calling the roll. Chair Schmidt.
Present.
Chair Schmidt, present. Member Sugarman.
Present.
Member Sugarman, present. Vice Chair Stein. Vice Chair Stein, absent.
Okay, so we have a quorum.
I don't have strong feelings about it.
Okay.
If there is whoever was meant to be called first, maybe if they're present and they want to if you want to ask them. But other than that, I don't. If I don't have strong feelings about it, so
Okay.
I will support you if you do not want to move it.
Yeah, yeah. Will, if there's any one of these cases where someone's not here, we could jump to another case and deal with it and then come back. Let's do it that way and not move the PUC case. Okay, yeah, so let's deal with each as they come. No agenda changes at this time.
Thank you.
Number 2.
Public comment?
Oh, I don't know if we need public comment on that.
Okay. Number 2.
Number 2, please.
Item number 2, approval of the March 25, 2025 Complaint Committee regular March 25 special meeting minutes. Approval of the March 25, 2025 Complaint Committee special meeting minutes.
So I only have one note on item 2. It says ayes, and then it says no. It's instead of no's, it says notes. Just a typo.
Thanks for catching that.
But otherwise, I'm fine with it.
I have nothing, so I'll move to approve, subject to that change.
Second.
Moved by Chair Schmitz, seconded by Member Sugarman to approve the March 25, 2025 Complaint Committee special meeting minutes.
Public comment.
Taking public comment on item 2. Anyone wishing to make public comment? If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. I'll give you a moment. We have no hands raised, no one approaching the podium.
All right, let's vote.
Taking the vote, Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Vice Chair Stein. Vice Chair Stein absent. 2 ayes, motion passes.
Number 3, please.
Item 3. Public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. If you'd like to make public comment, please approach the podium. We do have one hand raised. Hello, Mr. Karnazes. You've been unmuted.
Hi, this is Zach, Disability Activism SF. Hopefully you can all hear me.
We can hear you well.
Thank you very much. Couple of things I just wanted to share. First, I want to extend my gratitude for Patricia and this task force for helping me with some disability accommodations. I know it was kind of a slog and a lot of different ones, but it really, I just really appreciate it a lot. I think some people might not be aware that, you know, we as volunteers approaching this task force as you know, people filing complaints are unpaid, and we have to spend time away from our jobs, from our families and our loved ones to try to make this city a better place, try to hold these departments accountable to the laws that protect our rights to public records and public access. On the other hand, the departments themselves do get paid. Their staff do get paid very nice salaries a lot of the time, and they also get legal advice from the city attorney's office. So anything that can be extended, you know, as a help to the general public, be that an extension of time for submitting records or disability accommodations like this office did, are greatly, greatly appreciated. Thank you for your time.
Thank you, Mr. Karnazes. I'm lowering your hand. We have no one approaching the podium, no other hands raised.
Okay, general public comment is concluded. We can move to number 4 when you're ready.
Item number 4, file number 23092. complaint filed by Zach Karnassis against the Mayor's Office on Disability for allegedly violating Administrative Code Sunshine Ordinance, Sections 67.12, Section 67.15, and 67.25 by failing to provide an opportunity for members of the public to directly address a body on items of interest on the agenda. We have Mr. Karnassis. I will promote him to panelist. Mr. Karnassis, once I do, you will be able to raise and lower your own hand when you are asked a question. Mr. Karnassis, you're a panelist now. Is there anyone here from respondent on item number 4, file 23092? Please raise your hand in the app or press *3. I see no one from the respondent. I did reach out to their office to try and get a confirmation. I did not hear from anyone.
Okay, Mayor's Office. Okay, this is an office within the Office of the Mayor, is that correct? Okay.
That's my understanding.
Well, they're not here. And so let's note that. I will, we'll go ahead here. If someone shows up, then certainly let's see if we can get them involved here. But I think we should go ahead and hear this. Well, we could, no, let's hear this. Let's hear this. I'm going to explain the rules that we'll go by for the cases we have today. It looks like we're going to end up having about 5 of these cases. This is a complaint committee of the task force. We have read through all the documentation in the files, and so we do know a lot of the detail of the issues in these cases. We are going to today have you make presentations to us. So what we'll start with is we'll give the petitioner a chance to present anything to us, up to 3 minutes to start the matter, and then the respondent gets up to 3 minutes, knowing that you don't necessarily need to repeat what's in your papers, but anything that's you want to help us out with in terms of how we can deal with what we're going to deal with here today. We don't make any final decisions as a committee, but we do look at the merits of the case. We look at 2 preliminary issues. One is whether there's any jurisdictional questions, and 2 is, does this involve public records, public documents, public meetings, or not? And we may send the case to be heard by the task force. There are a few cases that we would not do that. We may or may not make recommendations. We will sometimes send cases to the task force on a calendar called the consent calendar, where the hearing before the task force is somewhat more of an expedited hearing. But I think that's everything about what we're going to do here. We're going to start with 3 minutes and 3 minutes, and then we, members of the task force, may or may not have questions to the parties. And then after the questions, we will decide what we're going to do with this matter that you have here today. And so after that decision, we'll move to the next case. Okay, that's it. Let's we've called the first case, and so let's go ahead and hear from the petitioner first.
Mr. Carnazes, are you ready for your 3 minutes to begin?
Yes, I am.
All right, your time begins now.
Hi, my name is Zach Carnazes. I also go by Disability Activism SF, where I try to advocate for disabled members in our community to have public access and our rights to enjoy civic life here in San Francisco, including access to buses and bathrooms and other basic necessities. I brought this to the attention of Sunshine Ordinance Task Force, not as a single issue, as a single occurrence, I should say, because that would be a waste of everyone's time if every time there was a technical issue or an issue of a public comment not being honored, if that was brought up to this task force every time. I mean, we would do nothing else but have meetings about that. However, this is a recurring problem that has been happening with the Mayor's Office on Disability, and it's one that I've made video recordings of, which I have on my YouTube channel, Disability Activism SF, on YouTube, and then also an MP3 recording that I submitted with this complaint. And I was surprised that the response from Deborah Kaplan was not one of like, oh, we've had some technical problems, we're working on it, but rather for her to say that this, we don't need to care about this because we don't feel this is we're under this jurisdiction, is surprising. Like, they did not even acknowledge that they have a problem with this when it's an ongoing problem. I tried to submit copies of those YouTube videos, but my fault, I did not submit them in time. However, I did email them to the board today. So if it's helpful, those are available to be reviewed at a later date. And I also emailed 2 of those videos of this problem occurring in other instances to Deborah Kaplan as well. It should be noted that Deborah Kaplan, the Mayor's Office on Disability, were found previously guilty for misconduct, or whatever it's called, by this task force some years back for not releasing public records that were my own public records for almost a year. And I only mention that because it's a pattern of behavior that is concerning. The Mayor's Office on Disability used to be a far more effective body in 2017, but a lot of staff members have left. There are some new folks that seem to be doing a really good job. Thank you. There are some new people that seem to be doing a good job, but I think our community suffers with Deborah Kaplan's role that she has with this body, and our ability to access basic participation in the meetings that have a very much a big impact on the disabled community. I should also note the Mayor's Office on Disability has been renamed to a different body, so that might have some difference in your decision. Thank you for your time today.
Thank you.
Thank you. Okay, unless we have someone here from the Mayor's Office on Disability, we can move on to questions that the members may have. And I will note that we have a third member, a special guest to our committee.
Member Kumar was noted present at 5:50 p.m.
Okay. She's going to teach us better ways to do things here today. Questions, anyone?
May I check one more
Yeah.
time? If there's anyone in the online community here for item number 4, file number 23092, please raise your hand in the app or press *3. One moment. I'm checking. Thank you, Chair Schmidt. Hello, caller. Are you here for item number 4, file 23092?
Yes.
Caller, you've been unmuted.
Yes.
You are. We are getting some feedback.
Can you hear me? Yes.
All right. Could you identify yourself, please? What is your name?
Hello, can you hear me? Yes.
We can sort of hear you. We're getting some feedback. Whatever you did, leave it there. Could we get your name, please? Maybe don't leave it there. Hello,
Beg your
caller.
pardon?
Hello, caller. We'll just stand by. Let us know when you're available.
There should be,
It seems there may be
there
a
should be no
telephone
requirement to give a
issue.
name.
There may be a telephone connection issue here.
So it seems. How
But we
about
can
this? You understand me now? Hello?
Yes, would you, promoting you to panelist. One moment, please.
We're trying to find if there's anyone here on behalf of the mayor's office.
Yes. Is there any way to mute the device that you're working on, that you're calling in on while we're talking? We're getting feedback from a device.
I didn't hear that this person is affiliated with the mayor's office. Are you still there?
Yes, I'm having some connection difficulties. Can you hear me now?
Yes, can you identify yourself, please? Are you here from the mayor's office?
No,
Thank you very much.
I'm a member of the public.
Thank you.
That's what we needed to know for now. So there's no one here on behalf of the mayor's office on disability. I'm going to go ahead with any questions to Mr. Carnezes. Members.
I have a question for the MDs.
Oh,
They're
microphone.
not here.
They're not here?
Yeah.
Then I'm.
No questions for Mr. Carnezes.
The question I did want to ask the department was, they said they had open general comment, public comment, but that wasn't available. I just wanted to know, from the department where that information is available on a Teams call, because as far as I understand, on Teams, unlike Zoom, there's is the agenda posted on Teams? I was just curious to know. Maybe the petitioner can give me some briefing on how the Teams call functions. Is the agenda posted in the chat? Are you notified in the chat that the public comment is now you can now give a public comment?
Yeah, I think that this is now sort of a question that Mr. Carnezes might be able to speak to. And so go ahead. Talk to Mr. Carnezes about what he knows, knowing that that's not someone on behalf of the mayor's office.
Okay. Hi, Mr. Karnezes. This is Member Kumar. So I wanted to know from you, can you explain how, say, I'm joining the call of the Office of Disability, and I have to can you walk me through on how these calls happen? How would you join them? When you join them, what is posted in the comments? Where can you see the information about the public comment? Can you just walk me through that process, please? Thank you.
Hi, this is Zach Carnezes, Disability Activism SF. Thanks for your question, Member Kumar. The attendance process is very similar to this meeting. So there is a posted agenda prior to the meeting, and it lists, when public comment is available for items not on the agenda. There is also public comment after each presentation. The way the Mayor's Office on Disability was structured is that different departments would give presentations about disability access around the city, and then members of the public could comment on that. It uses the same platform as this, which is WebEx and phone audio, and there is a chat and a Q&A as well. One of the great issues that I've had with the department is no one seems to be checking the chat during the meetings. So when there's technical assistance needed, no one's there. I've sent emails during meetings. No one's replied. This is unusual because the department used to be really on top of that. But to answer your question, there's nothing of an agenda posted in the chat. And the way to participate is the same as I joined the meeting today, which is to say I joined the WebEx platform or to attend by phone. And for this complaint specifically, it was a phone attendance. And what was heard in the MP3 that I provided, which is a recording of my comment, is that my hand was raised. And then there was an announcement by the telephonic system that said hand raises are now cleared, and everyone just went on to break. And that is, yeah, like I was sharing before, it's a pattern. It's not a one-time thing. But to answer your question, there's no agenda posted in the chat, and attendance is basically the same as attending this meeting here today and participation. Thank you.
Thank you.
Go ahead.
I have a follow-up question. So in this document, on page 23, I think, you had said that public comment was removed without notice. Was the public comment, did it not happen during the call? Or was it not posted on the agenda? It seems like it was on the agenda, right?
Yes, sorry, and I don't have that exact document to reference, unfortunately. I have, so I apologize. But yes, what that was referring to is that public comment is agendized, and there was an opportunity that I wanted to participate in, but could not.
But Mr. Carneses, my next follow-up question is, it doesn't really prove that the department, I mean, they didn't see your hand raised. It's not, it could have been a one-time thing, or does it happen to you quite often?
So yeah, that's why I was mentioning in my 3 minutes earlier that this is a pattern of behavior. It's not a one-time thing. And I've got video recordings showing the pattern of behavior as well. And I think Deborah Kaplan's response from the department that this isn't our jurisdiction, I think really speaks to the attitude of the department in regards to public accessibility to their meetings.
Okay, thank you so much.
So this is Member Sugarman. I'm just wondering, you said that it was different before. I believe you said the date you gave was 2017, but if it was maybe after then too, can you just describe what it was like before, when that was, and what your experience was then?
Sure, thanks. Yeah, I'd be happy to. Thanks for that question. So there was a staff member that used to work for MOD named Heather Cattell. And there was, different members kind of come and go. And I'm not behind the scenes. I don't really know what changes, but I know when Heather Cattell used to work for that office that they helped me with a lot of things, and getting food deliveries and stuff like that, that I was struggling with different departments. And I was so grateful to them. And if not that anyone would want to, but if you look back on the recordings from 2017, 2018, and before, I would go to their meetings and just praise them, repeatedly for how important their office is and all the good work they do. And there was changes. I don't know what happened exactly, but over the years, that department altered quite a bit. And I think the case that I brought forward, where I couldn't get my own records from the department for almost a year, is a good case in point that the task force heard for what those changes became. And there was actually another very unfortunate situation where I was not being allowed onto city buses in my wheelchair, and I reported it to the department for years. I went to their meetings in person. I sent documents. I did all the work I could possibly do, and the department couldn't be bothered to do anything about it. And that situation escalated so badly that I had to go file a lawsuit against the city, which was the last thing I wanted to do. We did settle out of court, and so that's now resolved. But that department exists to prevent those kind of things from happening, to prevent lawsuits from happening, and to help the public access city services. So that's been my experience with how the department has changed from one that used to help me access needs to one that's been very indifferent. And I would say nowadays maybe is outright hostile to the disabled community's access to even public comment for those meetings.
Thank you for that. One thing that I noticed, or it seems to be central to what their response is that, and also in what I'm hearing from you, is there is the Mayor's Office on Disability, and then there's the Mayor's Disability Council, which they consider a passive body. And so I guess my follow-up is, it seems to me that you have seen the entire office change, and I am on right now the Disability Council website, which says that it's staffed by the Mayor's Office on Disability. But it seems like they're holding these two entities as obviously as part of the same unit, but still separate. And so are there other meetings with the Mayor's Office on Disability that are outside of the Mayor's Disability Council? And have those been held, have those been any differently, in terms of how the calendars are held, if there have been those meetings? Or are they all held under the Mayor's Disability Council?
Thank you for that question. That's an excellent question. This is Zach again. I know it's quite confusing, and I don't understand all of the logistics. But first, to answer your question directly, as far as I know, there's only one regularly occurring meeting, and that is the Mayor's Disability Council. However, that meeting has a secretary from the Mayor's Office on Disability, and they're kind of joint. And so the staff turnover. The Mayor's Disability Council has some new staff in the past year, quite a few new council members. And for example, the Mayor's Office on Disability has their head of that department actually left in the past year. So there are some changes. And as I mentioned, Heather Cattell, who is the secretary for the Mayor's Disability Council meetings, who I believe worked for Mayor's Office on Disability, had also left some years back after doing some very wonderful work. So it is kind of confusing, right? Because they have similar names, but they're different bodies, but they serve similar purposes. As I understand it, the Mayor's Office on Disability was created in the late 90s to address accessibility issues in the city and to work as a body to sort of prevent litigation by working with the public and certain departments to make sure accessibility existed in compliance with the ADA and Title II and those kind of laws. The Mayor's Disability Council is a council appointed to hear from those departments, and I believe they report back to the Mayor's Office on Disability. But I'm not an expert in all the different nuances there, but that's sort of my understanding of it today.
Thank you.
Okay, I have, this is Chair Schmidt. I have a couple questions, and I will just note for Mr. Carnesi that I did see that there had been a request for accommodation here, and I believe, and this was a while back, that I asked how are these handled, because I think that we at least as a task force do have some responsibility to make sure that a request is responded to. I have some experience with ADA, FHA matters, and I know that's what's needed. I know that the response can be a lot of different things. I did see in the package here that there was, I believe, a substantive response on the ADA question. I think as a task force, that's not really in our jurisdiction, but I think it is something that we have to make sure is dealt with when it comes to access to our own functions. So it's not really something that we make any decisions about, but I think that since we're sort of involved in open government issues, I think there's often going to be an overlap with disability access issues. The best I can say is that if an issue comes up, I think we have to handle it one issue at a time. I think in this case, hopefully, the response that you got, I think it was from Victor Lim, was responsive. And, I understand that you're standing up for yourself in these matters, and I commend you for doing so. I know this is difficult stuff. Okay. The question I had about this specific incident is I got a sense that the order of things at that hearing was that there was a presenter of some kind, and then the calendar indicates that they held public comment right after the presenter, and then after that was discussion among the people who were on the council. And I'm not sure if you, I don't know what your expectation was, whether you believe you were there for the public comment right after the presenter, or if you thought that public comment was supposed to be placed after the discussion among the members. Could you tell me what happened in this specific instance that we have in front of us?
Sure. Yeah. Hi. Thanks for that question. Going off of memory of events, I've been going to these meetings for quite some time because I am very involved and interested in disability access and rights in San Francisco. And the way it's always been done is that they have a presentation, and then they'll take questions either from the public or from members of the staff, which is usually MOD and MDC. Sometimes they'll change the order of that. But regardless, I was there with my hand raised, and no one called on me for public comment. And to put a little bit of context here, this department is, especially when it was run very well, normally goes overboard to solicit feedback from the public. It's one of the reasons why it exists, is to get feedback about the accessibility of services. It's very unusual for this department to see a hand raise, or it used to be very unusual to see a hand raise from the public and to just not address that at all. Like if it was in the wrong place or the wrong part of the agenda, people, they would even say that in the meeting. Like we recognize a member from the public with the hand raise, public comments at agenda item so-and-so, or public comment will be after this. And there's nothing.
Oh, I'm sorry. Go ahead.
Oh, yeah, just saying that there's nothing like that. And I know that's a little bit extra, but there was nothing like that. And there's just overall a pattern of disinterest and blocking of public participation in these meetings.
Is it during the period that you just mentioned, on the day that we're talking about, was it during the period where they take questions when you had your hand raised?
Yes.
Okay. And so there was a call that they would take questions from the public. Was it called the public comment section of the meeting?
It was not the general public comment section. So it's not like a separate agenda item,
Mhm.
but what they do is they always take public comment after presentations.
After presentations. Okay. Okay. And so they will take questions, they'll take comments after presentations. Is that fair to say?
Correct.
Okay. But there's at this kind of meeting, and let's just maybe go to the meeting on that day, there's a single general public comment item on the agenda. Is that correct?
Correct. And similar to this meeting, that is at the beginning of the meeting. And
Okay.
and actually they have another one at the end of the meeting as well.
Oh, okay. Two different ones. Do you know if you made any comment that day in either the initial general public comment or the later general public comment?
Unfortunately, I'm sorry, it's been over a year. I don't recall.
That's fine.
I usually
That's fine.
do though.
That's fine. That's fine. I just wondered and you usually, you feel that this is something that you're able to do in other situations, give that general public comment, but not always.
Not always, yeah. So as I mentioned previously, in the past, before the past couple of years, this was never an issue.
Okay.
I've brought issues to this body before, like I said, the public records issue, but never, not generally this issue. And it's a more recent occurrence that it's becoming difficult now to leave public comment at these meetings.
Okay, thank you. No more questions from me. Members, any more questions before we deliberate and figure out how to handle this case? Okay, any thoughts? Should we send this forward? Do we have any questions about whether this is a public meeting? Whether we have jurisdiction? I'm not sure if I'm seeing anything in terms of those basic questions. What do you think we should do?
Well, jurisdictionally, it seems like it falls under 6715, right? Because I wondered the same thing, mostly because I'm used to public records requests or public records complaints. And whether or not we should send it forward, unless I'm misreading in the packet, their response is that they're a passive body. And I personally disagree.
Okay.
If you look at their website, it says that they are staffed by the Office on Disability. And if you look at their agendas, their current posted agendas, they have public comment periods that specifically cite that you are entitled to make them. They're not done in the same way that it seems that we see them done in regular meetings. But I think that's a complaint that I've heard across multiple meeting structures. But to me, absent a response from them or discussion from them, personally, it just looks like it's not a passive body in the way that they're describing themselves.
That may be a fact issue because they're asserting that it's a passive body. And the rules on passive bodies are going to be different. Mm-hmm. And whether we would find that they didn't comply with the rules, I'm not sure if I would necessarily see this situation the same if it's policy body versus a passive meeting body. And I'm also not sure if I would think it's passive or policy. Mm-hmm. I'd lean toward maybe it's a passive meeting, but I think there's enough sort of question here that it's probably something that in this case, we should move forward on. I also think that there's maybe an issue about whether this was really a public comment session in the same way that if a policy body makes decisions and they put a decision before the public, at that point, they offer public comment. This seemed like it was a little less formal, like a question and answer session. So I don't know if that comes under Brown Act myself. And also we have a question about whether there's obviously, I don't disbelieve Mr. Karnazes that he had his hand raised and there was just nothing, and he was there, wanted to talk. I think they sort of deny that that was the case, that they deny that they saw that the hand was raised. And so that's a factual issue. I don't know if we could really decide that one as we are here. And even if the hand's raised and they say they didn't see it or et cetera, I don't know if we're going to find out that's a violation or not. So those, I think, are the issues that I see here. Yes.
Yeah, so I'm going to differ a little bit. I feel that this case should go to the EOTC. It's not for the complaint committee, and it's because, first of all, I feel that I don't see a violation. It's like they didn't see his hand raised, and that could genuinely happen. But that said, they seem to have a history with not being with accessibility, which is a shame because it's the Office of Disability, and they're not being accessible, not letting people speak or give public comments. And I think the EOTC can actually train them to, make sure this doesn't happen in the future. That's what I was thinking.
Well, they're not showing up now, so I don't know what EOTC could, and this is just me brainstorming it. Like, I would, hypothetically speaking, I would think that EOTC would probably draft a letter to them if they didn't show up to that meeting either. I do think that it's more efficient to have it on a smaller committee level to have them address this. It's peculiar to me because I see your point about policy versus passive now in a little bit different light, because I'm looking at their agendas where it's like their agenda, at least the one that I have open, it's just informational items. They're not actually creating policy with them, but every one of them says public comment and then they cite the Brown Act in it. So it's like, why go through the trouble of all of that and then not provide like access for them to, especially if it is, I have not been to this meeting, but it's also like, especially if it's, because it also says in there, well, we can limit the public comment. It says right here, it says, in the interest of time, comments may be limited to a shorter time when there are a large number of public comments. And what this person is saying is that there aren't, like no one's there anyway. So it's not really like rational. So I kind of agree that like it could be done better where someone like to me it just feels like there honestly is a violation, and it is still like kind of a jurisdictional question, because if you still have to determine whether it's a violation based on whether it's a passive meeting body. So for that reason it could go to the full board, but in the interest of being more efficient, it could go to EOTC if we thought that that would do anything, which personally, I don't think it will.
Yeah, it's a good idea. I've never sent something to a different committee in this task force, but it makes a lot of sense what you're saying. Although I wonder if we could, with the way that you believe that committee would handle it, could we wrap that into have the whole task force just decide all of this, what to do with this thing? And it is do you think that, and then maybe that could be rolled into a motion at that time?
Right.
Any thoughts on that?
I did think about that, and then I also thought there could be a possibility when it goes to the task force, it's again sent back to a committee. And then I was like, why don't we just rotate it within the committees and make a final decision before sending it to the task force?
Mhm.
Because I'm getting a feeling that it might come back to a committee if we cannot take a decision.
Mhm.
Because if we're already divided it among 3 people, the task force has like 11
And-
people. Like,
yeah,
yeah,
part of
we might be divided there too. Yeah.
It sounds like. Go ahead.
The next EOTC regular meeting is scheduled for July.
Yeah, that was what I was about to go with it too. Is it sounds like we're pushing it around and it will end up at the full board anyway. Like I feel like the full board then EOTC is probably not only more efficient, but also like then the full board doesn't come to us and say, why didn't it come to us first?
Okay.
Okay,
Makes sense.
but I mean, like I said, they're not here. I guess also it's a good reason to bring it to the full board because we now do have someone from the mayor's office here, so we could have that discussion with them at this point.
Hopefully they would be present for this. Yes, Member Kumar.
The next EOTC meeting is next week. Can we put it on the agenda for next week?
It is, there is not sufficient time to put it on the agenda for the next week.
Okay.
I'm leaning toward, I really appreciate that idea and I'm mulling it over, but I'm still sort of leaning toward, we just give it a general push forward to the task force, and then these same suggestions should be brought up when it's at the task force. That's my thought.
Okay.
Is
Yeah,
that all right?
I agree with that. I think it should go to the task force. I don't want to delay it. Now that Pat said it cannot be, I was sort of visualizing that we put it on the agenda for next week. That's why I suggested it, but I don't want it to get delayed. So makes a lot of sense for it to go to the task force first.
Okay, great. All right. I'm ready to make a motion unless someone else wants to make one.
No, go ahead. But I will
Sure.
report it.
I'm going to move that we find that this is this does involve public meetings of some nature, and this does it arguably is within our jurisdiction. So I think that we should send this to the full task force to consider and make a decision as to the claims made.
I second, but I can help firm up the language, I
Sure.
suppose. Move to send to the full task force for possible violations of for questions on jurisdiction and possible violations.
Excuse me, just a moment. Could you state the possible jurisdiction statement?
Move to send to the full Sunshine Ordinance Task Force for consideration of jurisdiction and possible violations of the Sunshine Ordinance, Section 6715. That's where I see it.
Okay, do we have a second?
I'll second.
So who moved?
Do you want to? Yeah, I will either move it and Member Kumar can second it, or that could be moved by Member Schmidt and I can second it.
I like Member Sugarman's wording much better. So it's
Second.
it's its motion.
Been seconded by Member Kumar. Yeah, for me, it's just that the Brown Act and all of the public comment periods that are cited in here. Because I mean, I don't know if I haven't seen enough of like the agenda items to see that they take any actions, and that is a question of whether if it's actually legitimately a passive body for that reason.
Yeah, I think this is one of those ones that kind of floats in between passive and policy, and maybe it's just sort of a judgment call on our part, which it is. Even there's been questions about whether the Sunshine Ordinance Task Force is policy body, and I think it very likely is, but people make the claim that it isn't.
Yeah, but if you look at, I'm like I said, I only have this one open, but it's literally an information item, information item, information
Yeah.
item.
Mhm.
So for like Sunshine, regardless of whether or not we have, policies that are broad reaching or anything, we do have discussion and action. They're never just discussion, you know?
Yes.
May I get clarification on the motion? I have moved by Member Sugarman, seconded by Member Kumar to refer the matter to the task force for consideration of jurisdiction and possible violation of 67.15, and refer the matter to the full task force to consider and make a decision on the claims made.
That's correct.
Thank you.
And we have a second. And so let's go to public comment. Oh, question. Yeah.
I just wanted to add to your point, even though they're claiming to be a passive body, if you go to their website, they have ADA compliance trainings.
Yeah, it's all over there.
It's all over there. They also assist, and they explicitly say we assist city departments in making all their programs, services, activities, and facilities accessible to San Franciscans. So if your whatever you're discussing is helping other departments, I technically don't see that as a passive body, but I don't know if they're defining themselves. I think this should come up with the task force.
All right. Public comment? Anyone wishing to make public comment on item number 4, file number 23092? If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. I'll give you a moment. We have one hand raised, no one approaching the podium. Hello, caller. You've been unmuted. Do you have public comment on item 4, file 23092? Hello, caller.
Let me change. Can you hear me now? I do have public comment, but let me change something that there seems to be a loose connection here, okay?
Thank you.
Take just a moment.
Yeah.
Hello, can you hear me okay?
Not
Hello,
really.
can you hear me?
You were better a moment ago, I'm afraid.
There seems to be a loose connection, and I'll try and speak.
This
Is that better if I speak like this?
This is okay, yes.
This is good enough. Yeah.
Okay. Let me know how
Just
much
a
time
moment,
I have.
please. Let
Maybe
me
give
get
me
a
a
timer.
30-second warning.
Yes, and just a moment, let me get a timer. Are you ready for your 3 minutes to begin?
I am, yes.
Your time starts now.
So this is Peter Warfield, head of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. We are not a party to this and are not particularly familiar with this case, and unfortunately I came a little bit after the start of the presentation. So the first thing to say is I certainly support the motion very enthusiastically, and I'm glad you've come to that decision. I'm a little bit troubled by a number of things, but to keep it simple, the complaint specifically cites both the Sunshine Ordinance and the Brown Act. And it also cites more sections of the Sunshine Ordinance than you have referenced, and I don't know that you have discussed or considered those other sections that the complainant has complained about. So the complaint on page 6 of 63 in the attachment, there's another page. The actual complaint was filed, and it mentioned page 8 of 63. Please submit the below violation, include Sunshine Section 67.12 and 25 of the Sunshine Ordinance, as well as California Code number 6253 and under California Public Records Act 6250 et seq in this complaint. Neither of the Brown Act asserted violations or requested violations to be included, neither one is mentioned either in the summary that you have prepared, in the complaint summary, so-called, and to my mind, a little bit troublingly, is that there's no mention of Brown Act in the response of the agency. They start their response on page 3 of 63 by referencing just 3 sections of the Sunshine Ordinance
30
and
seconds.
nothing about the Brown Act. So I certainly think that all of the complainants' concerns and citations ought to be individually and each one reasonably considered. The other thing is, I think you do have a larger concern about open government, and I think that the agenda packet would be extremely misleading, as pointed out by, I think, Member Sugarman and so on.
Thank you. That concludes your time.
Okay, thank you.
Thank you.
I actually want to add, I did look at 6712 and 25. To me, first, like I said, from my reading, it felt like 6715 was a greater, basically it was a better place to target. But I actually agree about maybe referencing something in the motion about the Brown Act, because it is also in their meeting agendas.
Yeah, we could just add it in after 6715. Is that okay with the second? Okay, let's do that.
And what is the Brown Act section, please?
You could say general and
Considerations under the Brown Act is what I would want to put.
Does that mean another public comment?
is Victor here? It may technically mean that, yes.
Could you repeat that question? I was.
Victor, the action has been amended to add a violation. Does that mean that there is a second call for public comment?
Yes, the motion has changed. You should ask for additional public comment on the new motion.
Thank you.
Yes.
Taking public comment on the action, adding a violation of Brown Act to the violation of 67.15. Anyone wishing to make public comment on this item? If you're in the room, approach the podium, please. If you're online, raise your hand in the app or press *3. Mr. Warfield, that is still your hand raised.
Okay, thank you.
Did you want to make a second public comment?
Yes, indeed. Thank you.
Okay. Are you ready for your 3 minutes?
Yes.
Your 3 minutes begins now.
Thank you very much. And thank you for the alteration in the motion. I certainly support that and appreciate your considering it and making that change. I did want to say that one reason that we're talking here is that we've had experience with a similar problem, not with this agency, but with another agency. And they were found in violation based on a complaint that we filed in basically their second commission meeting during COVID for not having given us a reasonable opportunity for public comment. Just as another consideration, some folks who are really concerned with facilitating public comment, I give an example that happened at the Board of Supervisors. I tried to call in at a Board of Supervisors meeting during COVID, and there was a technical problem with the mechanism of the software. Luckily, I was able to call the clerk's office, which was still open at the time, and they tried to patch me through, as they would call it, and were unsuccessful, presumably with a similar or same problem. Eventually, a fairly short time went by, and they passed a message to the then president of the board, Supervisor Walton. And so what he did was he just simply, without making any big deal out of it, he said that we had additional public comment. And so he reopened public comment, and then they also, there might have been some action that had to be reversed, either opening public comment or maybe even something more substantive. In either event, he reopened public comment very simply, and actually it ended up, I was like the last of 6 people who were interested in making public comment. So it is possible to accommodate somebody who is interested in public comment, even if you've closed public comment for whatever reason, and to allow them to make public comment on the matter. So I think that the question of good faith is important. I also noted that the instructions on the body's agenda says that one of the ways you can call is on a smartphone, and that's all they say about a phone on that point, at that point. Thank you.
Thank you. We have no one approaching the podium, no other hands raised.
Let's vote.
Taking the vote on item 4, file number 23092. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein, absent. 3 ayes. Motion passes.
Let's proceed.
File number 5. Item 5, file number 25028. Complaint filed by Anne Marie against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Sunshine Ordinance, Section 67.5 by failing to hold open meetings, 67.7 by failing to post an agenda, 67.15 by failing to allow public testimony, and 67.16 by failing to record and post minutes of regular and special meetings of the board or commission. We have both parties present. One moment, please. Ms. Mabbutt, you have been made a panelist. You'll be able to raise and lower your hand now. We have Ms. Pariah Day from the museums. You've
Okay.
been made a panelist.
Yeah, so we can, let's proceed with 3 minutes first from the petitioner, and then we'll move to the respondent.
Ms. Mabbutt, and I apologize if I'm mispronouncing your last name. Are you ready for your 3 minutes to begin? Don't click anything. I'm going to unmute you.
Okay, can you hear me now?
Yes. Would
Okay.
you pronounce your last name for me, please?
It's like rabbit, mabbit.
Thank you. Are you ready for your 3 minutes to begin?
Yes, thank you.
They begin now.
Okay. Good evening, task force members and staff. Thank you for your time. I would like to clarify the primary purpose of complaint number 25028 is to establish if the singular or serial attendance over time of a majority of members of the Fine Arts Museum's Board of Trustees or a standing committee thereof has rendered COFAM meetings public meetings, as that term is defined by Sunshine Ordinance Section 67.3. This complaint is not attempting to independently impose Sunshine Ordinance requirements on COFAM, a private organization. The respondent is FAMSF and the FAM trustees who attended COFAM meetings in a manner that appears to have triggered their Sunshine Ordinance open meeting and public records obligations. In the April 25th, 2025 Fine Arts Museum response to this complaint, FAM Representative Pariah Dea, I apologize if that's not correct pronunciation, states, FAMSF has an independent public nominating committee which makes recommendations to the full FAMSF board. This is absolutely not true. Ms. Dea herself sent me emails earlier this year confirming FAMSF has not had a nominating or executive committee since at least 2019. I provided copies of these emails to the task force. I hope you've had an opportunity to see them. I did not have an opportunity to submit these in time to include them in the agenda packet because I did not receive FAMSF's response to this complaint until after the deadline for submission had passed. If FAMSF does have an independent public nominating committee, then how does FAMSF explain the total absence of any posted agendas or minutes for nominating committee meetings over the past 20 years? FAMSF also provided a city attorney memorandum dated 2/5/24 in support of its position in this file. This memorandum is not relevant as it discusses the potential application of public records laws to a private organization. This complaint is not against COFAM. It is against the FAMSF trustees who have been conducting the public's business privately for more than 20 years under the guise of their status as COFAM trustees. Between November 2017 and June 2019, the
30
same...
seconds.
Only 30 seconds left.
Yes.
Is that what you said?
Yes.
This reality is the result of the actions of the self-perpetuating FAMSF Board of Trustees, the members of which voluntarily choose to concurrently serve as COFAM trustees during their tenure on the FAMSF board. It is a relationship drenched in conflict of interest that has persisted unchecked for more than 40 years and has had disastrous consequences from an open government and from a financial accountability perspective.
Thank you. Thank you. Are you ready to hear from respondents?
Yes, please.
Okay, one moment, please. Hello, Ms. Day. Are you ready for your 3 minutes to begin?
Yes, thank you.
Your time begins now.
Good evening, task force members. My name is Pariah D, and I'm here this evening representing the Fine Arts Museums of San Francisco. As stated in our response memo that we sent on April 25th, in response to file number 25028, the Fine Arts Museum's position is that COFAM is the Corporation of Fine Arts Museums is a private supportive nonprofit that's separate from the Fine Arts Museum San Francisco, the city department. It's privately funded. It doesn't receive any financial support from the city and operates fully independently, its employees, et cetera. I do acknowledge that over the years, the Fine Arts Museums has had significant overlap between its board members for the nonprofit and the city department. We have been working, especially over the last couple of years, in trying to separate out the boards and have come more closely to that in recent months. The Fine Arts Museums does have a nominating committee that did hold its first meeting on May 5th, and it's a practice that's going to continue. It is a open meeting to the public, and the meeting minutes, agendas, and information is available on the Fine Arts Museum's public city website, and it is a practice that will be continuing forward. The Fine Arts Museum is a bit different from many of the other city boards and commissions in that per the city charter and since its establishment that it does self-appoint its own board members, and we are actively working on making that process more transparent and including this nominating committee. And as stated in our memo, we did have a file number 22052, which last year, in February of last year, there was a memo that was attached to our response from the city attorney's office that helps to further detail the relationship between the city department and the nonprofit and the ways that they operate and work together, as well as explain the city attorney's position that the Fine Arts Museums is separate from COFAM and that the Corporate Fine Arts Museums, the nonprofit, is not subject to
30 seconds.
the Brown Act or the Sunshine Ordinance. And that's all. Thank you.
Thank you.
All right. Now we may have questions for the parties. I know I have a couple of questions myself. Members, I'll go ahead. Mainly I have maybe one or two questions to Anne Marie, and it's more just your description of what this is about. It seems to me that the particular question we're answering here is whether the document request that was made should have been responded to. And the reason that the response was not made is the claim that COFAM has no responsibility, or that there's, since it's a nonprofit, those documents would not be, I guess, not be public documents, and so they don't have to produce these. Is that fair? It's sort of a combination of at the state level, the CPRA and a Brown Act question wrapped up into that. And that's just, hopefully that turned into a question somehow, Anne Marie.
Oh, okay.
Tell
Can you
me
hear
what
me now?
you. Yeah.
Okay. What I was trying to reference in my initial comment was just, I don't have a copy of the Sunshine Ordinance right in front of me as I'm speaking right now, but I thought there was direct language that said, the task force has jurisdiction to determine if meetings are public. So if these meetings that a majority of FAM trustees, if in fact a majority of FAM trustees attended them either at one single meeting or over time, a majority attended these meetings, they are public. And then from that public status flows these requirements.
Got it.
Open minutes, agenda, record, opportunity to testimony. So I really feel like the proper way or the easiest way to think about it is flowing first from, were these in fact public meetings? And if yes, then what are the consequences in terms of disclosures and opportunities?
Okay.
Violations?
So the crux is a meeting of COFAM, a public meeting based on who is actually involved in that meeting. And we all know who those people are. They're the same people who are with, maybe with one or two exceptions, are also with FAMSF.
Right. And I mean, it's very hard. I mean, it's all very garbled. And I would like to state, though, in response to one comment, just to clarify, I believe, and up until at least 2019, because they have refused to provide copies of bylaws since that time, COFAM, that up until that time in the COFAM bylaws, whether or not this could even be lawful, but it was in practice followed, there was a language that required the FAM trustees to serve on the COFAM board during their tenure on the FAMSF board. And those COFAM bylaws were approved by FAM trustees. So this overlap has been significant until at least 2019. And until we get a look at these bylaws, we don't know how muddled it still is.
Thank
It's
you.
a deep and persistent overlap. And
Yeah, let me move to Ms. Dea. You said that there had been a meeting this month, I think it was May 5th, of a nominating committee that at this time exists with FAMSF. Did I catch that correctly?
That's correct. The meeting took place on May 5th.
Okay. And so there's a committee. How many people are on that committee?
There are 3 members on it. The committee consists of the president of the board, the vice president, and one other trustee that was elected to be on the committee at a previous full board meeting of the FAMSF board.
Okay. And when was that meeting when that board met to choose those 3?
So per the bylaws, the FAMSF bylaws, the vice president and the president are automatically serve on the nominating committee. And I believe it was the April 2nd meeting of the FAMSF board where that 3rd person was selected to be on the nominating committee.
Okay. So before that nominating committee was created in April, do you know when the last time there was in existence such a nominating committee with FAMSF?
There wasn't. This is one of the things that in my role I've been working on is to make sure that we are making these processes more transparent for the public. And previously it was more, discussions between, individuals, I think in a similar way that maybe there's just discussions where people are thinking about people for other commissions or boards in the city and someone throws out a name and it kind of moves from there. But because we do have this, the process is really internal because we don't have our trustees selected by the mayor or the board of supervisors or some other body, that this nominating committee is for us now, I think, an essential part of making our process more transparent for the public.
Okay, thank you. Members, any further questions? Okay, no questions at this time. Oh, Member Kumar, yes. Sure. If there's no question, I'm trying to train Chair Yankee on this. If it's not a question, let's get done with questions. And so let's say, okay, no more questions. Now we're deciding the case. Okay. And now is when you make the comment. Thank you.
Okay. I just wanted to say I see a clear violation. It's just I'm just shocked that there was no nominating committee. They've explicitly said they had no such committee in 2020, 2021. I get it was the pandemic, but the public should have been notified. And if there was no notice to the public that there is no committee like this, that is a violation. I would say that is an additional violation to all the other violations that's listed here.
Thank you.
I kind of, in looking at this, got a little caught up in, because I just remember when this did come up vaguely. And so I went and I looked back at, which I can't even open right now, but I had it open just a minute ago, basically a memo from the city attorney's office that was explaining the different relationships between these 3 organizations. And apologies, while we were discussing this, I was a little caught up in just reviewing that. And my question is, are these still the same I understand that there's this question about the nominating committee, but are these still the same members functionally from FAMSF and COFAM in terms of like who's on the board?
That's my understanding is there's, you know, either a dozen or more, maybe up to 50 or 60 people involved here. And there's pretty much 90 to 100% overlap with people who are with COFAM and with FAMSF.
Okay.
Which that in itself is not necessarily problematic, but that's how it is. And so, yeah,
So
yeah,
as
there's total overlap.
As the petitioner, points out, essentially, it's not a question about whether COFAM is a private body. It's a question of whether it falls under Sunshine. And what the city attorney's memo said is that if a meeting of COFAM would functionally constitute a meeting of FAMSF because of this overlap, and that would fall under Sunshine Ordinance. So that's basically where that's all I have to contribute to this conversation, essentially.
Sure. And I think that's the argument. And the way I see it is that it is an argument that is it's a good argument. I'm not sure, though, for me, whether the theory here is that because the people from FAMSF are coalescing in a COFAM meeting, that they have that it becomes a serial meeting under Sunshine. And because they're meeting with COFAM and that they may be violating Brown Act by talking about museum issues in the context of a COFAM meeting. I'm not quite sure if I am sold on whether that turns the COFAM meeting into a public meeting. That's where I'm, and I think that's the crux of it legally to me.
Yes, Clerk Peterson. Sorry, after you're done. You had our hand raised.
I'm trying to follow the hands raised. We did have Ms. D's hand raised and lowered. We currently have Ms. Mabbitt's hand raised. Just FYI.
Okay, thank you. And so I don't think that this is something that in either direction is going to end up on the consent calendar.
Okay.
So I think that there's going to be members who think that, yes, this meeting would somehow, it would have enough Brown Act, let's say, aspects that the documents that are sought here, which are the records of the meeting, are public records that need to be produced. I'm not sure if I would go there, but I think some of the other members of the task force would. And so I'd probably make an argument that I just don't know if it turns the meeting into a Brown Act public meeting. I fully see that this relationship we're looking at here, FAMSF, COFAM, it has a lot of problems vis-a-vis.
We will continue to look at it.
Yeah, and we've looked at it from other directions. But, if we look at it in this direction, I think we are looking at potentially Brown Act violations. But I don't know if these documents become public documents because those people are committing Brown Act violations. And so we might even be able to say that they're violating the Brown Act by meeting outside of FAMSF in a in a way that meets a quorum. We may be able to say that in our ruling before the task force. I think it all ought to just go to the task force. And so I'm going to make a motion that we send this on for consideration by the full task force on whether there's been a violation of 67.21 for failing to produce public records. Anything you think I should add in there? That's the motion I'll make, which I'm just leaving it very simple.
I will second that. I mean, I feel like this one we could go on. I completely agree with you that like we could, it's not going to go to consent calendar anyway. It's just better to forward it than to debate it.
Okay, we have a second.
Moved by Chair Schmidt, seconded by Member Sugarman to refer the matter to the full task force for consideration of whether there is a violation of 67.21 for failing to produce public records. We still have two hands raised if you'd like to hear from anyone.
I think we've I
Damn it.
understand the hands are raised, but they're parties, and I think we want to move through this. It's going to the full task force anyway, so I respect their interest in speaking to us, but I'd say save it for the full task force, because it looks like we've got a move motion. So anyone for public comment from not the parties, but from the public.
Anyone wishing to make public comment on item 5, file number 25028, please approach the podium or raise your hand in the app or press *3. I'll give you a moment. We have no one approaching the podium, no hands raised.
Okay, let's vote.
Taking the vote on item 5, file number 25028. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Vice Chair Stein, absent. 3 ayes. Motion passes.
Okay, thank you. When you're ready, we'll I think we should do one more and then we'll take a break, unless any members want to take a break now.
No, we'll do another one.
Okay, one more. Good.
Thank you, parties. Moving you to panelist.
Yeah, it's just.
I don't know what I'm going to do with this information.
I usually leave it there.
Oh, this.
Item number 6, file number 25029, complaint filed by Madison Alvarado against the San Francisco Police Department for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. One moment, please, while I move the parties to panelist. Ms. Alvarado, or Madison Alvarado, you've been moved to panelist. You can raise or lower your hand. Moving Lieutenant Ozol to panelist. Welcome, Lieutenant.
Okay, welcome to the parties. We will hear from Madison Alvarado for up to 3 minutes, followed by Lieutenant Ozol. When the timer is ready to go.
Madison Alvarado, I'm going to unmute you.
Hi, thanks for your time today, everybody.
Yes. Are you ready for your 3 minutes to begin? I'll give you 30-second warning. Your
Yes,
time
I'm ready.
begins. Your time begins now.
Thank you. Well, yes, I am Madison Alvarado. I am a reporter with the San Francisco Public Press who covers homelessness. And recently, I've been trying to learn more about how San Francisco handles illegal lodging complaints and cases for folks who are sleeping on the streets. And I have been trying to obtain records related to that, incident reports, citations, and arrest numbers. And basically, I reached out to Officer Robert Rueca twice in early March to get help filing a records request. because my attempts to just get answers from the department about the number of arrests and citations were unanswered. So I decided to file a records request, and after reaching out to Officer Rueka twice for guidance about how to narrow that request and not receiving a response, I decided to file a records request on March 19th. And basically the department repeatedly pushed back the date where I could expect a determination on my request. Sometimes just giving like arbitrary dates, and sometimes just saying they would give me an update in a few weeks. And in the time since I submitted that request, it's been really difficult to get a date on when I can expect those records to be released, despite numerous phone calls and email exchanges. Eventually, Officer Rueka told me that what I requested in my initial request wouldn't be possible. And so he shared some data layouts basically of the databases that I initially requested, and said I could use those to be more specific in my request, which I went through, and I narrowed that request and specified exactly what I was interested in, and basically have since heard that it would again be several weeks until I would get a response. In my experience with other departments, exporting data like this doesn't usually take weeks. I've asked other departments for data exports, and sometimes they've taken hours or a few days. I've repeatedly offered to speak with someone on the data team or someone who's familiar with these records to have a conversation about how I could narrow that request so it would be more manageable for the department, or so I could get those records response sooner. And the department hasn't been
30 seconds.
interested in that. Thank you. So yeah, basically I'm just hoping to get some clarity on when I can get those records, and hopefully get those records soon. Given that my initial complaint seems to be what spurred some action in replying to that request, I'm hoping that just part of this process today will help kind of move that request along. So thank you all for your time.
Thank you.
Okay, now we'll hear from the respondent.
Lieutenant, are you ready for your 3 minutes to begin?
I am ready. Thank you.
Your time begins now.
Good evening, members of the committee. Good evening, staff, and Madison Alvarado. Hello. Good to meet you for the first time. I am appearing on behalf of Robert Rueka, who was unable to attend the meeting tonight because he does have time off. I know that he has been working with Ms. Alvarado to provide the data requested, and I am familiar with the complaint and the timeline. And I received a letter from Officer Rueka kind of outlining the timeline of the complaint and his communications to Ms. Alvarado to respond and to clarify. I understand that where we stand now is that we are waiting for our data analysis unit to produce these records from Ms. Alvarado. I do apologize for this delay. Unfortunately, I don't have an exact date when they will be available. I can certainly understand the frustration, and I would love to be able to give Ms. Alvarado more of a concrete date as soon as Officer Rueka returns and we can speak with our data analyst team. I'm committed to making sure that this request is responsive, and I do apologize to Ms. Alvarado for the delay. I would just say to the committee to note that since the first request was made, Officer Rueka and our department have been in communication and trying to sort of come up with a plan and narrow the scope of the documents. That's certainly no excuse for the delay. However, we are on it right now. And unfortunately, again, I don't have a timeline for when that will be available. However, as soon as Officer Rueka returns, I will ensure that Ms. Alvarado, you do get more of a firm date that you deserve. And I wish I had a better response as to why you haven't gotten the information sooner. I
30
know
seconds.
it is, yes. So thank you.
Thank you. Okay, now we will move to questions that we may have of the parties. I'm going to just ask an initial question of Lieutenant Ozol. Is it fair to say that this request is still being worked on?
Oh,
The
absolutely.
process is ongoing, right?
Oh, most certainly. The most recent communication, I believe, from Officer Rueca to Ms. Alvarado was on May 5th, when I believe Ms. Alvarado, you and Officer Rueca spoke over the phone. And the most recent request to our analyst was on May 12th to request an estimated time frame. And we got several weeks to complete at that time. That was May 12th. However, it is in process.
Which of the personnel within the department are working on finding, identifying,
Yeah.
and copying, or like actually getting these documents to Madison Alvarado?
Yes, it's our data analyst team.
Data analyst team. Okay.
Yes.
And so that's a team that is that your office works with, correct?
Yes.
Okay. And
Yeah,
they have everything they need right now to go forward with this.
Yes, I would just clarify with Ms. Alvarado to make sure the latest I have, I believe, is, and Ms. Alvarado, you can help with this, was it the fields were narrowed down. I think we have a number of 72 and 65 for another data set. That was the last communication I had, that Ms. Alvarado was kind enough to narrow down the data set. So that is what is pending currently.
How does that sound, Ms. Alvarado? I think I saw that too, that you had narrowed. Does that sound like the current status?
Yes, and I think I guess with the narrowing down of the data set, I've been trying to have the opportunity to speak with someone on the data team, because I'm open to amending the request further, or like having a discussion about how to move the request forward. Because in my conversations with Officer Rueca, he doesn't always, like, he's kind of acting as an in-between. And so sometimes it can be hard to understand like why certain aspects, like why it was too broad in the first place, or what an ideal number of variables would look like, or things like that. And so that's why I've been trying to speak with someone on the data team, because I feel like that might be able to help us move this process along. But I mean, yeah, so I guess that's the only other thing that I would add. But yes, I did narrow it to, I believe, the numbers that Lieutenant Ozol cited, and I have been in contact with Officer Rueca.
Excellent. Thank you. Members, anything else? Question. Member Kumar.
This is for the department. How many members do you have on your data team? And my next question is, how much time does it usually take to parse through a data set?
Unfortunately, Member Kumar, I don't have the number of staff that we have on the data team. It's not in my unit. I could get that information for you. And then as far as the data sets, it really just all depends. I wouldn't want to speak on their behalf I know they're part of our technology team, but I would be remiss in trying to entertain, just how long that one is going to take, or something else, just because that's not my area of expertise, if that answers your question.
Okay, I have a follow-up question. So, why is the police department not allowing Ms. Alvarado to connect with the data team?
So generally, and I can't speak on behalf of the communications with Officer Rebecca, we would endeavor for the member who is responsible for obtaining that data and forwarding it to the requester to be the primary point of contact to allow for a more efficient request. The data analysts, I would assume, are busy working on their data sets, and if there were requests for clarification, they would certainly reach out. I would prefer to be the point of contact for these types of requests.
But if you are, say, like a middleman in this situation, aren't you technically like, I mean, everybody's, I mean, understaffed, departments are understaffed, overworked. I know we've had cases in the past with the police department, with the photography department having just like one person. So doesn't this like open it up to situations where, you cannot get the data on time and it becomes a situation where it flouts the Sunshine Ordinance? Like, I'm just trying to understand if there's any way we can circumvent this method, because it clearly seems to not be working.
Well, I would say that the method has worked well. It is not perfect, but the problem with sending individual members to individual units of the department is there's just no way of keeping track of the requests, the conversations, whether or not these requests are being met. So if we were to do that, there would be very little way for myself, for Officer Berwecka, to track or to understand to the extent that, members like, or the public, such as Ms. Alvarado, as requests are being met and fulfilled, because we would have a multitude of separate conversations going on.
Thank you.
Hi, this is Member Sugarman. Obviously, this does seem like an efficiency issue. I do have questions related to that. Because for me, it's more about like, because we have, both parties here and they both are interested in getting like what they, for the police department wants to get the data to the person and the party wants a certain amount of data, and potentially recognize the scope of the request, and how big it is. I guess my question first is for Madison, and for Ms. Alvarado, and how what would be, I understand that you want to connect with someone specifically on the data team, but if that's not possible, is there any part of the data that you're looking for that you would want imminently? Like, is there something that you might want more immediately? Like, how could this be more efficient for you, in a way where you wouldn't necessarily have to narrow your scope, but you would be getting at least part of the data?
Well, right now I have requests for two sort of data sets. One is related to citations and the other is more related to like incident reports and arrests. So I guess expediting the data set more focused on the incident reports would be like preferable, like if, we had to split the request into parts. Yes, does that answer your question?
Partially. Also, it looks that the records are from 2018 to present. So is there any part that you might want, like a time period you might want that's fewer than 6 years?
Yeah,
well,
I mean,
like sooner?
yeah, I definitely, and that's one of the things that I was hoping, like I would be happy to narrow the time period if that would help expedite the request. I just haven't been able to get answers on if that is the case. But I would definitely be interested, probably going back to say like the start of 2021 through present, as opposed to going back to, I think, the start of 2018. But you know, the more recent years are, if those can be returned sooner, that I would be open to that as well. It's just not clear to me at this point if, like, I don't know in the way that the department keeps their data, if filtering by time like that would have an impact on how quickly they'd be able to get it back to me, which is, you know, but yes, I would be open to
Right.
amending in that way.
And I understand that it does appear like there is a pipeline issue, which actually brings me to my next question to the department about because it seems as though Officer Rueka is the person who is the custodian of handling this request. When is Officer Rueka back from leave?
He should be back next week, and I will certainly get in contact with him as soon as he is back to assess the status and try to move forward.
Okay, and also for what Ms. Alvarado said, is narrowing the scope in the ways that she suggested, would those assist the police department? Not in the full data set. Obviously, it sounds to me like the full data set is something that the petitioner is looking for, but at least in terms of how it is released and in what portions are released, would that help the police department to do it in that format?
I will bring that up to the data team to see if that would assist them, and I do appreciate you suggesting the idea. I'm not sure if that would make it any faster by narrowing the data set, but that is a good idea to explore. And I, ultimately, if it does get it quicker, then at least we can be providing that recent data sooner, and then follow up on a rolling basis with the rest of the data.
Okay, thank you. Those are my questions.
Thank you.
No further questions from me. Anything else? And if questions arise, even though we've moved out of questioning, that's fine. We can ask them, but let's go ahead and see if we can figure out a way to move this forward. It seems like the parties are working together, and that's significant here. It is taking more time than is really allowed under Sunshine. I think that's going to be sort of why we get involved here. But there's basically a document request, and it's taking, you could say, even though it's complex, it's taking quite a bit of time to get the documents.
Yep. I'd say it's a consent item that moves both toward violation and then just to compliance.
Yeah, I think so too. Yes.
And when we do have a motion, can we add a line to the motion saying that, I mean, my concern is with the police department, this is a consistent issue where they're understaffed and they're not meeting, Sunshine records requests, and then it's a violation. Then they end up in the committee, then they end up in the task force, and we again add a comment that they should address this. I think the compliance committee should also there should be some form of action taken to make sure that the police department finds ways that these requests are addressed in a timely manner and they don't keep flouting and keep turning up at the task force. Because like I've been in the task force for like a year and a half, and the department that's mostly turned up, I don't have a data set, but from my recollection, it's mostly the police department. So I personally feel bad always like pulling them up for this, but I think we should, it's high time that they should actually either hire more people or figure out a way to respond to records requests in a timely manner.
I mean, I somewhat agree. I feel like the volume of requests they get must be quite high. And I honestly, like, just looking at the volume of this specific request, it does seem like it's a large request. But I do also feel like in sort of a related agreement to Member Kumar, it's just that, like, I also feel like when I hear about the police department, it is, can you narrow it? Can you narrow it? Can you narrow it? Can you narrow it? And there's never like an end scope to that. And the only part for me, like, I mean, I'm literally just commenting because I'm for a violation here, but like, part of that is because in listening to the police department, it does sound like they want to facilitate the request. It just also sounds like they're not there is no remedy for the pipeline issue. Like and maybe I'm not really sure what that would look like, but it is like there's this one person who's in the middle, and then there's a person who's assigned to the case, and that's there is no like change of that hierarchy or like a suggestion for something else, or in the remedies that the petitioner has agreed to, that would even advance the timeline any faster than it is now by narrowing the scope or narrowing the date range.
Yes.
I'm not sure if the police department uses Excel, but if they do, when I used to use Excel, if I had a massive data set, I would just use the filter option and like filter down the categories. It's not that difficult to do it quickly. That said, I don't know how many data sets we're dealing with. It could be the data sets have to be combined together. I would say using ChatGPT would have made sense to maybe like, or some other tool, but I know the police department has its own restrictions in using different tools, to especially for data sets. That said, I believe if they have, I would love to know how many people they have on this team, because I think that will sort of give me an impression of whether, if they have a significantly big team, then obviously my next question is, why are you not able to, address the request in a timely manner? Why are you asking the person to narrow the journalist to narrow down data sets? Because at the end of the day, as a journalist myself, if I'm being asked to narrow down the data sets without knowing exactly what's in the data, I don't know what I'm missing out when I'm writing my story. So that's a concern for me too, with data. I mean, with text, obviously you can look at headings, you can narrow down things, but with data, it's also a dangerous territory to not get the entire data set. So yeah, I just wanted to say that I think I would love to know how many people are in that department whenever this case comes up next.
That's fair.
Let me just say that we found out a while back, the member Stein of this task force, in sending out questionnaires to create the annual reports, she found out that the police department gets something like 60,000 public records requests a year, and it's probably about 4 times the number of any other department. And so that's sort of the context here. That's sort of one of those things where in a perfect world, they would simply be able to hire a lot of people to deal with those requests. But we're not in a perfect world. And it does, we get good glimmers from the police department. I think I understand that that's a lot of requests. And so we're going to get some that are going to come to the task force. You would think statistically that we'd get 4 times as many as from any other department from, requests that are made to the police department. That would just be the logical thing that we might see. And I think that I think all we can really do is we can make the finding that the statutory time has been exceeded for a request. I think we're all understanding that, yeah, this is a hard request and there's a lot of records requests. So we're not dense about that. But we make the finding that there's a violation because they didn't meet the statutory time. And then we make an order that the documents are to be produced, the documents that are still not produced. And I think consent's fine with me.
Yeah.
The consent calendar, because that order is very simple, and that's all we can really do. And then we just send it, like you say, to compliance. And one thing compliance would consider, as Member Kumar said, is what to do, if anything, about the PD here. So we just have to word a motion. I mean, the last motion, so I don't want to be glory hog here. Yeah.
Motion to find a violation for 6721 for the San Francisco Police Department to not provide public records in a timely or complete manner, and move that to our consent calendar with a recommendation to find that violation and also to forward to the compliance committee
For
adherence to the records request made by the petitioner.
And I heard an order that the records be produced. Could I get clarification? Is that the records as requested or records narrowed or just
I think that it's just put records as requested. It is I want to make a comment. This is not part of the motion, but it has been discussed with both parties that that the petitioner is willing to at least segment that in terms of when those records are received and in what narrowing. But I think that that the records should be. I agree with Member Kumar that like you don't know what data you're missing, and it seems like as though the request was already narrowed. So I believe it should be as requested.
could I get clarification on the referral to
Compliance.
to compliance for monitoring?
Basically,
Would that be
for
structured?
follow up with compliance within how many days would you say, Chair Schmid?
I'd say as soon as
As soon as possible. As soon as possible.
Yeah.
So at at their next earliest meeting.
Yeah. When you're ready, I've got one thing I want to change to that motion.
And when is the next meeting for compliance?
June,
June.
fourth week of June.
But that's actually too far.
Well, we're not ordering anything.
Okay.
This has to go to the task.
Yeah, that's true. That's true. It has to go to consent. Okay.
Chair Schmidt, I'm ready for your.
Yeah, I would ask that instead of saying recommend a finding, that we just say we order that the documents be produced pursuant to section 6721.
Okay.
So still finding the violation.
Yes.
Yeah, we
Then-
find a violation and we make the order under 6721.
That the records be produced as requested.
Yes.
Okay.
And it's a consent matter.
Mhm.
As you got that right? Consent.
yes.
Okay. Good.
Yes, forward to the consent agenda for June. Calling for public comment on item number 5, file 6. File numbers. Calling for public comment on item 6, file number 25029.
Just clarifying, I'm the second on that one.
Moved by Member Sugarman, seconded by Chair Schmidt. Thank you. Anyone wishing to make public comment on item 6, file number 25029? If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one approaching the podium, no hands raised.
Okay, we can vote on that.
Taking the vote on item 6, file number 25029. Member Sugarman.
Aye.
Member Sugarman, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Kumar.
Aye.
Member Kumar, aye. Vice Chair Stein is absent. 3 ayes, motion passes.
All right. Let's take a 5-minute break. How about come back at a quarter till 8, 7:45. Let's come back. Okay.
The meeting is in recess. Microphones are off. Microphones are on. Meeting has resumed at 7:46 p.m.
All right, next, we got two more cases today. Next one.
Item number 7, file number 25030. Complaint filed by Barclay Sanders against the San Francisco Public Utilities Commission for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner. And 67.27, by failing to provide written justification for withholdings. We have respondent present, moving Mr. Sanders to panelist.
Okay, let's hear from the parties, up to 3 minutes each.
Hello, this
Hello,
is
Mr.
Barclay
Sanders.
Sanders.
Your 3 minutes begins now. I'll give you 30-second warnings.
Thank you. Hello, my name is Barclay Sanders. I'm speaking on behalf of the SFPUC letter dated April 11th, where they invoke a vague rule of reason to slow roll public records requests. This records request was submitted under Sunshine Records Request on the Next Request portal, and they had stated that I had filed too many requests. And the main reasons I write requests is because they're not required legally to respond to resolutions written by the SFPUC CAC. And the only way that I can get them to respond is by submitting records requests and pushing them by writing resolutions. But essentially, once I file the records requests in relation to Harlan Kelly, who's currently serving a 4-year prison sentence, they invoke this rule of reason around the records in relation to him and possibly Treasure Island. So I just wanted to make a comment on that and cover that there's been over 511 outages on Treasure Island in the last 25 years. And just this year alone, I've had to submit 11 records requests, even one in the last 24 hours because there was another outage, so that I can understand what's going on the island and what maintenance is or isn't being done and how they're trying to truly decrease the outages to their levels that they deem acceptable, which is about 3. But it just seems interesting. Once I submitted a records request for the records in relation to Harlan Kelly and Treasure Island, out of all the requests, they now have started to invoke those rule of reasons and decrease the time that they will spend on these records requests and in the nature of how they will respond. So it seems like it's in a violation of the Sunshine Ordinance. And if there is a rule of reason, does that apply if an area has 11 outages in a short period of time? If there's records that are getting produced because there are so many outages, it's not my fault that there is so many outages.
30 seconds.
So I'm just trying to deeply understand that if an area has 511 outages, that's not my fault. So if I have to submit a lot of records requests because there is so many records in relation to this, it just doesn't seem reasonable to deny my request for those documents. And if they need to leverage AI tools, there's many that are out there.
Thank you. That concludes your time. Thank you.
Thank you. Let's, when the timer's ready, let's hear from the respondent.
Ms. Noonan, are you ready for your 3 minutes?
Yes, thank you.
Your time begins now.
Good evening, members of the Sunshine Ordinance Task Force. My name is Chloe Noonan, Public Records Manager at the San Francisco Public Utilities Commission. And I'm here tonight with Chelsea Boylard, Director of Strategy, Planning, and Innovation, to help answer any questions. We are here to present SFPUC's response to Sunshine Ordinance Task Force complaint file number 25030. We respectfully request that the complaint committee dismiss the complaint without further action from the task force. The complaint refers to a recent notice sent to the complainant stating that SFPUC will apply a general rule of reason to the complainant's current and future public records requests. As background, the complainant has submitted 65 requests to SFPUC since January 1st, 2024, 40 of which have been submitted during this calendar year. The requests are often complex, require clarification, have multiple components, and involve a multitude of documents. The number and extent of complainants' requests far surpass requests SFPUC typically receives from any other member of the public. On April 11th, SFPUC sent the complainant a letter invoking a general rule of reason in SFPUC's responses to complainants' public records requests. The letter states that due to the burdens the requests have placed on SFPUC staff's ability to perform our other public duties, SFPUC will allocate a limited number of hours per week responding to the complainant's requests. The complainant alleges that by issuing the rule of reason letter, the SFPUC violated sections 67.25A, 67.21A, and 67.27 of the Administrative Code. However, none of the provisions of the Sunshine Ordinance that the complainant invokes have any bearing on or relevance to the rule of reason letter, nor any of complainant's requests. Complainant also referenced Task Force Order of Determination number 19041, which, based on a brief review, does not exist. The City Attorney's Office advises that city departments may invoke a rule of reason under certain circumstances. And the Good Government Guide specifies that this includes circumstances where a series of requests from the same requester has cumulatively imposed extreme burdens on a department. SFPUC has not imposed a cap on the number of requests that the complainant may submit, and that was not the intent of the rule of reason letter. The letter simply sets forth the bases for invoking the rule of reason in response to complainants' numerous and burdensome requests, and further describes the manner in which SFPUC will continue to process the complainant's requests. SFPUC values the policies of transparency and the public's right to access public records, and we remain committed to upholding these tenets. We invite the complainant to continue to submit records requests, and we will continue to respond to any such requests in the manner stated in the rule of reason letter. Based on the foregoing, SFPUC respectfully requests that complaint number 25030 be dismissed. Thank you.
Thank you.
Okay, members, any questions for the parties? I'll ask the respondent, what is the status with regards to I know that Mr. Sanders sounds like about 60 different requests, and we saw those in the file. And I don't disagree that they might be complex, but what's the status of producing records in response to those?
Thank you for that question. We have released records and closed a request the past couple of weeks. And in addition, we released 118 responsive records to the complainant this week.
Okay. And so it sounds like you're beginning to, I'll call it, roll things out to Mr. Sanders in response to the request. All right. Okay. And Mr. Sanders, you're not having any problem obtaining what has been released to you as just described, right?
They responded to some of the records requests, if that's what you're stating.
Yeah, I'm just wondering
if Kelly one.
If you got the records.
I've gotten the records that they have released on the Next Request website, but I haven't gotten the ones that aren't closed. And the reason there is so many records requests is because they don't have a standard process after an outage to release the records in regards to maintenance. Like I've been on multiple boards for upwards of 5 years, working with multiple departments for free on my own time to try to solve a problem that the city doesn't want to. So if you want to holistically look at the amount of records, there was 23 outages last year. So at minimum, I'm going to request 23 records requests in regards to the maintenance around those outages, the notices that were sent, because it's just basic governance to know what's going on. And then this year there's 11. So like essentially half of those outages are half of those records requests are because there's so many outages. But even if I want to talk to anyone within the SAPUC as the chair of the CAC, I can send an email, but that doesn't require them to respond. I can pass a resolution, but it doesn't require them to respond. And that's why even the new person that's named Joshua Arce responded, and he said that he would come to every SAPUC CAC meeting himself and show up. But before I did these records requests, before I got onto these boards, and before I requested something in relation to Harley Kelly, they would respond. But like, why was there a change of tone when I'm specifically targeting someone that's serving a prison sentence? Like,
I think I got a sense of what I was asking for. The question I asked was just about if you are having any trouble obtaining what is being produced. Okay, thank you. There was a mention that these requests, as if they're added up, they make Mr. Sanders sort of the most requesting party to the PUC. How many requests? Can you give me an estimate? How many requests, public records requests, do you get a year at the PUC?
Approximately 600 to 700 records would be the estimate.
Okay, thank you. All right. Members, I think that's all the questions I have. Okay. I will say then we'll move out of questioning. I've just drawn the line there. We may still have discussion as the members wish. Yeah, I think that this is another case where, 59 requests. It is a very big project to respond to these. There's no question about it. And so, what do we do about that? I will point out that I know that the city attorney has this rule of reason that they talk about. I'm not a huge fan of the rule of reason. I'm just saying this in my own opinion. They've taken something that's actually a fairly narrow doctrine of the law, and I'm the attorney on the task force, and the way that the city attorney presents it in the Good Government Guide, I think it doesn't help because it makes it look like it's much too broad. I think that this kind of set of requests would justify what's called a rolling production, where you're sort of churning things out. You have, say, 59 requests. Well, we're working on them. We're doing 5 a week, et cetera, et cetera. And so the city attorneys talked about in other cases, let's do a rolling production. I could see that would be appropriate here. I will say that in California law, there is a standard whereby a department can say, whoa, that's too burdensome. You're asking for thousands and thousands, tens of thousands of documents. But that standard is surprisingly expansive. I mean, under the state law, there's a case, I'll just point out, Getz v. Superior Court. It's a 2021 case. And for the record, it's 72 Cal App 5, page 637. But they had a request there that was for something like 80,000 documents. And so there was a response that, oh, well, that's too much. It's burdensome. And the court, this appellate court actually said, no, it's not burdensome, which is, I was sort of surprised because I thought, whoa, how do you respond to something like that in time? Impossible. And it might be that the standard is impossible, but I just want to make the point that the law does really impose a very stringent requirement that even large document requests have to be processed quickly. And I understand that the other objection, rule of reason, is what's being asserted here. I know the city attorney for San Francisco, I haven't seen them talk about rule of reason as much, since I don't know if they even read what I put in one of our annual reports, but I did an analysis of the rule of reason. And the task force adopted the analysis. But I just think that it's not being used in the proper way. Those are my comments about these burdensome production cases, because we are looking at several of those right now. And we do have sympathy for people who are trying to figure out, how am I going to ever get through all this? I understand. Yeah, so those are my comments. I don't see anything problematic about the document requests. Like, they seem like they're valid requests. I will stop and let the members speak.
In contrast, not that there is an apples to oranges comparison, but we just spoke to a requester who had essentially one request that was high in volume because of its scope in the date range and potentially, like, the number of incidents. Whereas in this one, while I agree with you that the documents requested are valid, you can look at the requests themselves and they are, as the respondent says, quite layered and overlapping. And in that way, on its face, like just looking at them as I am right now, burdensome. I'm not saying that doesn't mean they don't have to, provide them. Mm-hmm. And I'm also in understanding, like I take you without knowing enough about the reasonable burden, like basically what you're saying, that like it's a scope that what you were saying, that that you still have to provide these documents essentially, it's I understand that. It doesn't sound to me like like I said, again, looking at the other case, it doesn't sound like in this one that there's a remedy. It doesn't sound like from the petitioner's perspective, if you're looking at, for example, the number of outages that are happening in Treasure Island, and you're looking for information from the PUC, it doesn't actually look like from the requests that they are necessarily asking for the same thing in each one. Like it's not like you're not looking for like a specific type of data that could be like streamlined and somehow created into a manageable process for the PUC. And I'm not saying that that's
Are
necessary.
we allowed to make comment?
We're not doing comments right now. I'm not saying that's necessary to have like a uniform way of doing that, but also it doesn't seem like there is like there's a level of conversation happening between the two parties to get the documents in a way that like is efficient for both for them to handle the request and for the requester to make the request. So I don't know. My question is to you, given that you're saying that essentially what I'm hearing is that the respondent's argument to dismiss it is not what you're looking toward because you still think that these documents have to be produced. I agree with that, but then what violation are you looking for?
Mm-hmm. And I will answer that, but I want to give Member Kumar a chance, and I'll answer that after that. Yes, ma'am.
I'm gonna take a page from the police department's book and say they could have easily requested the petitioner to narrow down the request, or instead of just imposing a blanket general rule, it does, I do see a violation of 6721 because unless the department can provide me evidence that they have in the past imposed this rule to not give out data when it gets overwhelming for the department. But if this is a one-off case, I feel the department and SFPUC and the petitioner can definitely work together to narrow down the scope of the request and work on finding on getting the data to the requester. I don't see why that cannot be done.
Thank you. Okay. Back to Member Sugarman's question to me, what's the violation? I think that we're not making any decisions here. So just to get back to, we don't have the power to make decisions. We can't dismiss anything, et cetera. We're just a committee. And so we might make recommendations to the full task force, which is 11 members. But we can't decide finally. I think that, our preliminary questions, it looks like there's no jurisdictional question, and I don't think there's any question that these would be public records. So that we will confirm, I believe. I could see a reading of this that they are appropriately invoking this rule of reason because of the massive size of all these requests. I could see a reading of that, and I could see that members might agree, because I can only speak for what I think of the case, but not necessarily, everyone is in agreement here. My position would be that the standard is not the rule of reason, and the rule of reason is actually to me, a reasonableness standard. And it's a weird rule. It dates back to like common law. It's 1946 case that the city attorney relies on. I don't understand why they got the word reason in there. And I think that people take it as being, oh, well, we just do it's reasonable. That's okay. And I think the city attorney has given people license to do that. I think we could, make a decision that this is overly burdensome and therefore they need more time. to produce, and so therefore they haven't committed any kind of violation here. I think that we could say they've taken too long, and they've, by not producing faster, that they've violated the 6721. I could see that as a possible result here. I could see that the blanket announcement that, oh, everything you do will from now on be dealt with under the rule reason, that itself could be, it's almost like a ahead of time, we're going to deal with you differently than everyone else, that would be a violation. I could see all those as possibly being what the task force would order. I think the answer to your question is that what they're considering is there a violation here
Right.
of 6721.
Right.
I think that's it. And so I don't know if we make a recommendation or send it to the consent calendar, but I think we, put it before the task force.
I think that you're right. In the last part you said about what they said about invoking it to the petitioner about the rule of reason, because it is basically like saying that this is how we're going to treat this going forward. It's what I was saying about the conversation breaking down too.
Yeah.
So for me, I can't feel comfortable. Like a 6721 is a 10-day rule for requests that are coming in like a few times a week. But I can say I would forward it to the full board for consideration for 6721 violation and just have that discussion there is what I would probably do.
Okay.
I would, yeah, I agree with that.
Okay. I think that's, again, we can't make a final decision, and it would just be a hearing where parties speak, to check on the status of what's happened with any kind of document production that has existed. I think that we then figure out a majority of the board think that there was any kind of violation here by anything that the department's done. While we're not putting a hold on anything, I think the production should continue, any kind of production that. Okay, so I will then make the motion. We find jurisdiction. These are public documents. And we're going to send this to the full task force to consider whether there's a violation of Section 6721.
Second.
Moved by Chair Schmidt, seconded by Member Sugarman, to find that the task force has jurisdiction, that the records are public, and refer the matter to the full task force for consideration of a violation of Administrative Code Sunshine Ordinance Section 67.21 for failure to produce records in a timely and/or complete manner.
Let's check if there's any public comment on this.
We have no one in the room. If there's anyone in the online community who would like to make public comment on item 7, file number 25030, please raise your hand in the app or press *3.
Am I allowed to make a public comment on my own thing?
Sorry, you get a chance to talk more about the case. We've got to set it before the full task force, and we've pretty much done what we can here.
Thank you.
So we've got to move forward. Sorry.
Thank you.
To other cases. Yeah, but thank you.
Thank you. We have no public comment.
Let's vote.
Taking the vote on item 7, file 25030, Chair Schmidt,
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Vice Chair Stein absent. 3 ayes. Motion passes.
Thank you to the parties. Okay, we've got another item here. Oh, actually, the next item, let's figure out what we're going to do with it. And I think it may be an agenda change.
Okay, so read item 8.
Oh, yeah.
Oh, it's the Lynch case, right? Is that what it was? Lynch said that he told you that he's not going to show up, but it came in after the period where they can ask for a continuance. I'm not sure, but
That's correct.
I'm talking out of order. It's your call here.
Calling item 8. File number 25031, complaint filed by Ben Lynch against the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner.
I don't know if the MTA is here for this.
They are not.
They're not. Okay. Then we didn't put them out a couple hours. Okay. Lynch wants to continue it. I guess that's an option that we'd have. But Lynch didn't show up, right? What happened here?
He was unable to make it to the meeting.
Okay. And when did we get notice of that? Was it 8 days ago or 5 days ago or something?
I don't have the date, but if you'll hold on just a moment, I can look.
Members, if you want to continue this, I'm open to that.
I'm okay with that.
Okay.
Okay with not doing it if they're not here.
Okay. Move to continue.
I also wanted to point out, don't want to get too nitpicky here, but there's a typo for file number 25030, San Francisco Public Utilities Commission. There's a typo there.
Okay.
I second the move to continue.
What's the typo?
San Francisco is spelled incorrectly.
Oh, okay. Okay. All right.
Okay.
Thank you.
Thank you.
Okay, we'll move to continue. I moved.
I seconded.
Okay, second. Sugarman, second.
Move to continue to the next complaint committee agenda?
Yes. Or the next, yeah, let's keep it in this committee since we did the reading.
Public comment?
Yeah.
Anyone in the online community wishing to make public comment, please raise your hand in the app or press *3. We have no one in the room and we have no one online wishing to make public comment.
Okay, let's vote.
Taking the vote on item 8, file number 25031. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Vice Chair Stein absent. 3 ayes, motion passes.
Okay. All right, so next item.
Item number 9, file number 25032. Complaint filed by Michael J. Turan against Assessor Recorder Joaquin Torres, Aiden Salim Kayali, and the Office of the Assessor Recorder for allegedly violating Administrative Code Sunshine Ordinance Section 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner, Section 67.26 by failing to keep the withholding of records to a minimum, and Section 67.27 by failing to provide justification for withholding information. Additional allegations: violation of California Government Code, Section 7922.525 and 7922.535 sub A. We have both parties present. One moment, please. Mr. Turan, Aiden Kayali, you are both panelists. You may now have the ability to raise and lower or turn your mic on and off by yourselves.
Okay, let's hear from the parties. Up to 3 minutes for each.
Mr. Turan, are you ready for your 3 minutes to begin?
I am, thank you.
Your time begins now.
First, thank you for continuing the hybrid meeting format. It makes access to these meetings for families with toddlers like ours, allowing us to participate. Second, thank you for the opportunity to address the members of the task force, and extra thanks to all city staff for all their efforts in making San Francisco great. The key concern at hand is the assessor's refusal to produce a detailed record-by-record withholding index as mandated by Section 67.27. This index is the linchpin of transparency. It forces an agency to identify each withheld document, cite the specific legal grounds for withholding, and explain whether any portions can be released with redactions. Without that structure, the public cannot fairly judge when department's blanket references to Revenue Tax Code Section 408A are valid or overbroad. Why this matters: when an agency withholds a public record, the Sunshine Ordinance requires more than a generic citation to a confidential statute. A well-documented index brings clarity, which is essentially critical here because the BOE-64 forms at issue are labeled, "This document is subject to public inspection." If the city withholds records in this manner, property owners remain in the dark about how to lawfully secure or verify partial seismic tax exclusions on their property. Such uncertainty undermines both civic trust and public safety efforts. Proposed path forward. I respectfully ask the task force to adopt the proposed order of determination attached as Exhibit L in the brief, which directs the assessor to 1, produce a record-by-record withholding index that meets all requirements of Section 67.27 of the Sunshine Ordinance. Number 2, release the non-exempt portions of any withheld documents, including BOE-64 forms marked for public inspection. 3, respect the expedited immediate disclosure rules in future requests. Conclusion. My aim is not to burden the assessor recorder's office, but to uphold the Sunshine Ordinance's core primary principle: government duty to serve the public transparently and in full view. In this case, enable property owners to submit complete seismic exemptions to the assessor recorder's office. I appreciate the task force time and believe that compelling the assessor recorder office to produce a complaint index and release all non-exempt information will preserve the fairness and openness that the San Francisco Sunshine Ordinance stands for, including Prop P. Thank you. I remain open to all questions from the task force.
Thank you.
Thank you. Go ahead.
Aiden Kayali, are you ready for your 3 minutes?
Yes, I am.
And I apologize if I have mispronounced your name.
Oh, no, it's all good.
Your time begins now.
Hello, committee members. My name is Aiden Kayali. I'm the junior analyst and custodian of records for the Assessor Recorder's Office. I'll try to keep this as brief as possible, but on February 14th, we received a public records request from Mr. Turan requesting the 5 most recently approved BOE-64 forms, staff communication, internal guidance, and decision memos stating that these records were to be used as an example for his own filing. After Turan's follow-up on February 19th, I had notified him that a search for records was being conducted and consulted with members of other divisions within the department in order to seek out the records. We received a second follow-up from Mr. Teron on the same day, the 5 most recently approved BOE 64 forms were provided. Teron requested confirmation that there were no further records, and a 3-day timeline was provided in order to reconfirm with the members of the Real Property Division. On March 4th, I confirmed that no valuation records were found and provided additional information about when a valuation is triggered through an extensive project that includes seismic work. This information was given to me by the members of our Real Property Division and was passed along to Mr. Teron. The following several requests made by Mr. Teron regarded the valuations and memoranda for these extensive projects. And each time it was reiterated that although an extensive project would trigger a valuation, there are no records for the partial exclusion for the extensive projects, and that one record exists related to internal guidance. I say that this internal guidance document is protected under Revenue and Taxation Code 408A. And I would also like to add that a similar request had been brought up by Mr. Teron that did go to a full hearing on May 1st, 2024, where it was determined these records are not public and are exempt from disclosure under 408A. Thank you.
Thank you.
Thank you.
Questions? Okay, I'll start. To the respondent, how many documents do you believe exist which are within the scope of what was requested, but were not produced?
So the BOE 64 forms were requested and produced. However, the internal guidance that was discovered was withheld.
Okay, so you describe a withholding, and that's on the basis of the code section, correct?
Yes.
Okay. Is that how many pages are we talking about here?
About how many pages is the internal document?
Yeah.
About 3 pages, 4 pages.
Okay, so if you were to look at Mr. Teron's full document request, do you believe that he's gotten everything requested that exists except for that 3-page document?
Yes.
Okay. And you believe that I'm going to strike that. I think that's all the questions I have for you at this time. I'm going to just ask Mr. Teron, why the documents that have the designation that they're public disclosure, it seems like the respondent is saying that they've given you all of those, but you're contending that maybe they haven't. Could you explain that?
Yes. So as the assessor recorder's office stated, there is 2 sunshine requests. The first one was for all 5 examples of a seismic exemption, which is for the committee's pleasure. Basically, when a homeowner decides to do a seismic upgrade to their home, then they have to go through this detailed process of getting multiple departments' evaluations of what parts of the project are a seismic upgrade, which ones are not, and then get an evaluation from the building department, which is then passed over to the assessor's office to and see if the assessor will allow for the exemption. In that first request, the assessor recorder basically said, here are 5 examples where people just only did a seismic retrofit on a project. But then they clarified that there are projects where people have a seismic retrofit and do additional items to their property. Example, you do a seismic retrofit to 3 stories, which covers a kitchen. So you end up having to remodel a kitchen. And then you decide to put in some skylights or move around some walls during the seismic upgrade. That's considered a partial exemption project, which is what was clarified in that first request. And that's what I'm trying to do with 2 projects at my home. And so after finding that out, I asked for not only the forms, but for memos and for assessments, because the key word that the assessor recorder stated on these partial exemption projects is they don't go by the cost anymore, but they go by the value. So it becomes really difficult to, as a property owner, to navigate through how to get the right value of what's exempt and what's not through both the building department and the assessor recorder department. So my second request basically asked for any partial exemptions, any internal communications, any memos. And the assessor recorder produced nothing. They did not produce a single BOE 64 form for a partial exemption. They produced no files for property owners who tried to do a partial exemption but were denied. They didn't provide any communications or memos or guidance. And then on top of that, they said, look, we've got a document, but we're going to use this broad exception and not give it to you. And so I'm sure this is a little bit frustrating for the assessor recorder's office, but I went back and forth with them several times asking for the release of the document with an index, more specification, because I believe that it's quite broad and I'm just trying to submit a project that will be accepted. And after a little bit of back and forth, we ended up filing this complaint.
Thank you. Mr. Turan describes how there was a request for further BOE 64 forms and that he got nothing. Question to the respondent, do you think that there are such documents that exist, and were they withheld?
No, the documents don't exist, and the BOE 64 forms were provided for that because we don't have any partial exclusion documents on record, but we have the full exclusion, and that was what was provided.
Okay. So the request as worded, that second request, which talks about partial, your response is that that kind of thing, the documents do not exist.
Correct.
Okay. All right. And I want to ask Mr. Turan, you talk about an index and you cite 6727. I know that 6727 it talks about citing authorities, but I just need a little help. Is there a place in there where you think supports the idea that an index is required?
Yes, I do actually. So in 67.27 A through D, that's the section I cited. And then in my legal brief that I provided to you guys, I believe it's in Findings of Facts and Conclusions of Laws, section 2, subsection C. I actually provided 2 past SOFTA file numbers where they made decisions that departments needed to provide a detailed withholding index. And I would turn the members' attention to that. That's file number 16071, Borden versus the Planning Department, and file number 20084, Anonymous versus San Francisco PUC.
Okay. Okay, thank you. So you're basically saying that the task force in those 2 cases ruled that an index had to be created. That's
Yes.
what you're saying.
Yeah,
Okay,
and I would
got
say
it.
that should be some persuasive, obviously past SOFTA determinations are not binding, but
Yeah.
I would hope that, you know, the members would find that highly persuasive.
Yeah, thank you. And I do appreciate you giving that to us. And I think we'll be sending this case to the full task force for a decision. And I'm sure that there will be discussion of how compelling those other situations are. And we should be talking about that. There's no question about it. It's an important issue. Thank you. Okay, that's all the questions I have. So Member Kumar, your turn.
We have someone from the Assessor Recorder's Office, right?
Yes.
Okay, I have a question for them. My question is, in terms of the data that was requested, was there any data that's sensitive and cannot be provided, and this information was relayed to the petitioner?
May you clarify the question or elaborate a little further?
Sure. So, in all the information that was requested, was it ever notified to the petitioner that we cannot respond in a timely manner because there's some information that cannot be provided? Is there any information that cannot be provided that was intimated to the petitioner?
So the only information that was not provided was the internal document, and everything else was provided that existed.
May I know the reason it wasn't provided?
So this is an internal guidance document related to how the appraisers go through the seismic, and we believe that in general our office policies are exempt from public disclosure because they also contain confidential information related to our internal functions, whether this be investigations, reviews, and audits, including information about how or when taxpayers are selected for scrutiny, review, or audit.
I do want to understand, is it not possible to get this document after redacting sensitive information?
To my knowledge, no, it's not.
Okay,
As it's an internal document protected under 408A.
Wait, sorry, he said protected under 408A.
Yes, he's saying that it's not so much that it isn't possible.
Can I ask that you use the microphone, please?
Yes, sorry, Member Kumar. This is Member Sugarman. Member Kumar was asking something clarifying. I will phrase it in a question. You're saying that regardless of whether it's possible to share, it is precluded under tax code 408A.
Yes.
They weren't going to share it, that's all.
I have a question for the chair.
Go ahead. Oh,
in deliberation.
Anything else for the witnesses? Okay, or the parties, yeah. Okay, so we're gonna possibly be done with questions to the parties and we're gonna deliberate. Go ahead.
So this is my question. I have not dealt with this kind of a case before, so I wanted to know what is the task forces stand on 408A documents that cannot be provided? Can we ask departments to provide that information even though they legally cannot do that?
What I would say is what we do is we are told that 408A is the basis for withholding a document. And then so we can look at 408A and make a determination that that's actually a proper basis for not producing. I'll give some other examples. A document that's attorney-client privilege is one example. Documents that come under the CPRA under the stated exemptions.
Right.
Those are the examples of documents where they tell us what the objection is, and here they said it's 408A, and we decide is 408A actually a valid and we might ask them questions about the nature of the document, and we might ask them those questions based on what 408A says, but we can't compel, we don't have the power to compel that we could look at that document. That's beyond what this task force's powers are.
And as I believe the respondent had said, that we had decided that they were a similar instance where they were protected under 408A. I would also say that, of course, in the process of listening to this, that I read 408A, and they do seem like they're not they do seem like they don't survive CPRA, like they don't look like public documents. But my question to the chair is also what the petitioner says about being more detailed about it and this index. Should there be more information provided under the law in terms of why and how many documents there are, et cetera?
Yeah, I think that there are cases that we've seen before the task force where we will insist, for example, that for a place in a document where there's a redaction, we will ask the party to say, okay, that word or those words, what's the objection? What's the legal site for that objection? And so I think that we can insist to that extent, and it's called keying. So this is the keying idea that the petitioner, the person who requests the documents, should be able to figure out from the keying or some other process which objection applies to which withheld information. Now, the reason I ask about index is I am not quite sure if I'm seeing that an index is required. I think that certain information is required, but to me an index is a very specific thing that I would probably say I don't think it's required. I know that the task force, the petitioner says that the task force required that in 2 past cases. And so I certainly don't discourage people looking back at those cases, see what the context was, et cetera. And, then you learn from that. It could be persuasive to you. I agree. But I don't know if in the language is you need to cite the specific authority. Cite the specific authority. That's what the law says. And so, to me, okay, did you cite the specific authority? Here, we're talking about a 3-page document, and they said it's 408A. So your question to yourself is, did they cite the specific authority for the withheld document? And I don't see that there's anything that's being withheld here other than that single 3-page document. Does that answer your question?
Yeah. I feel like I don't know. It doesn't feel like forwarding this to the full board is going to be helpful.
Well, okay.
Because the respondent is definitely not, they don't seem like they are going to release any information based on the tax code. It sounds as though, unless I'm understanding it incorrectly, you don't see a violation under the tax code, and it's questionable whether there is one under 6727 based on this indexing issue, which I'm not personally, based on what you said, also, I'm not persuaded that there is necessarily. So
I'm not sure. I'll put it this way. The respondent says that everything that's public that would exists was produced. And I'm not quite sure. I mean, we can speculate and say, well, there's probably other documents that they should have produced. But I don't know if that's anything more than speculation here, other than the 3-pager. The 3-pager.
Yeah, no, they said that they didn't produce the internal memo and that they weren't going to.
Yeah.
And I don't see that.
Yes.
I'm getting the impression that even if this goes to the full task force, we might just be running around in circles because they seem to have a solid reason to not give the document. Like they'll probably be like, my impression is it'll go to the task force will send it back to a committee, or like they'll keep saying we are not going to give it. That's what's going to happen.
Well, yeah, that's just my question to both of you is there a violation?
I'm going to give you maybe an answer I'm going to sort of change the trajectory a little bit here, because this is a 6721 case. And so my reading of 6721E is that this person brought a petition to us, and the law says that they are 45 days, they're entitled to a determination, whether or not there's anything that needs to be produced. It may be a determination that we find no violation, and that's it. And so, or it could be that we determine that we're going to order that something further be produced, although it seems like we've already talked about, we're not sure what that would be. And so I think that my vision of what we can do is just, we could try to tell the full task force as much as we can about what we think the ruling should be. But I think there has to be an eventual ruling, and it's supposed to be within 45 days, that involves the entire task force. So I'm not quite sure if we can like kind of put the brakes on it here. And I know that's kind of come up before, because I think that I even suggested a procedure when we were talking about like changing up procedures where something doesn't actually have to go to a full task force hearing. We compromise, we came up with consent. And so therefore,
Right.
this could be a consent item.
Right. Well, so that's kind of where I'm headed. I see your point. It could be a consent item or a full board item, but it basically forwarded to the board that we have jurisdiction with a recommendation for 6721 violation, but that no records. We don't believe there are records with the complaint committee's suggestion that there are no records to be produced. Like it's a timeliness violation.
Timeliness.
Right. And I mean, you could put consent, but consent would also automatically it would move it ahead. You could just put it toward the full board. They would have to come up here again and argue it again, and we'd be here in front of 11 members. But I see your point about timeliness, though. So.
Oh, I don't know if I was.
Well, 6721. I mean, like failure to produce it.
Oh, no, I'm talking about the timing, the 45 days that we have.
Yeah. Okay.
As opposed to,
Well, they were filing, according to this, they were filing extensions, though, like the assessor's office was, like saying there was.
Yeah, their extensions may have been a timeliness violation.
Mm-hmm.
And so, we could here say, well, we're going to make either a recommendation or a consent calendar submission saying there's a timeliness violation under 6721, or we could say there's not. But yeah, that's one of the issues is the timing. Are you saying that you think that's kind of what is the substance of what we're seeing, because you're thinking, well, there's nothing else that could be produced anyway?
I feel personally, and this is honestly, I don't know that if a number more was in this chair, I don't know that I want to make this decision. Like, I don't want to tell you to put it on consent. But that is how I feel, where it's like I feel like I don't see if we're taking what everyone has said as the value of it, where the assessor's office has said, well, we didn't have other documents except for this one that we believe we're protecting for valid reasons. And I look at the code and it seems like those reasons look valid to me too. I mean, it's not ideal for the petitioner, but like, I don't see another way around that to be like, well, like I would say that there's no violation, for that reason. But like, I don't know that I feel comfortable putting that in my own hands just to put that on consent and say that. But that is where I stand with it. I don't see something else around it other than
I'm pretty much where you are. The only question I have is, they did take a lot of extension, like you say. So it might be that if we're asked the question, did they take too long? Did they violate the provision on time? We either if we're going to do a consent, we're either saying that they didn't do anything wrong with regards to time, or we say they did do something wrong with time. So I think other than that, I'm fine with consent, and I'm fine with consent about, like they've said, there's no further documents, and there's nothing that we can really look to think that that's not true from our view on this. So I think we could do it with a consent. The only question is, did they take too long? What do you guys think about, do you think they took too long?
I think that's fine.
You do? Okay. Then I would either move or I'd second a motion that says we move this to the full task force consent calendar with the finding of a timeliness violation under 6721.
I guess I'll phrase it. You support this though, Member Kumar?
I do.
I would say that we move for the consent calendar for a timeliness violation. But that no productive records need. No, there were no further records to be produced. The word's not productive. My brain's now dead. What is it?
Or we could say timeliness only, or we could say, but no order to produce.
Yes, something like that. Or just a timeliness violation. That's fine too. But
I'll second it. Any of those
Sorry.
wordings is fine with me.
I need clarification. Okay. Finding is that the task force has jurisdiction, that the records are public, and to refer the matter to the full task force consent calendar for a timeliness violation, but no order to produce. And I also have no further records to be produced. What's the last element, please?
No order to produce further records.
The only part in there was that the records are public. The ones that they requested and received were public, but by saying that, I don't want to imply that we're saying that the internal memos were public. So move to Sunshine Task Force consent calendar for 6721 violation. We find that we do have jurisdiction. And that all requested records that could be produced have been produced.
I'll second that.
Brains illegal words are no longer coming.
In the statement, all records that could be produced were produced. Is that all public records that could
All
be produced?
requested records have been produced. Well, no. Because they haven't, because he wants those other ones.
So we turn to all records that could be produced were produced.
Yeah, could you just read it to me? I apologize.
Action to find that the task force has jurisdiction, that all records that could be produced have been produced. Refer the matter to the full task force consent calendar for a timeliness violation.
I think that's, yeah, that works.
Is that okay?
Yes. If anyone wants to update my language, please.
Public comment?
Member Kumar's a second, I think, on that, right? Yeah.
And I'm sorry.
Public comment, yeah.
And I'm sorry, who moved?
I moved it.
Moved by Member Sugarman, seconded by Kumar. Public comment. We have no one in the room. Members of the online community, if you'd like to make public comment on item number 9, file number 25032, please raise your hand in the app or press *3. I'll give you a moment. We have no one in the room, no hands raised online.
All right, let's go ahead with our vote on that.
Taking the vote on item 9, file number 25032. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein, absent. 3 ayes, motion passes.
All right, next item.
Item number 10, hearing on advancing the Sunshine Ordinance Task Force, section 67.30, roles.
I think just to explain to Member Kumar that this is sort of an item where we have an ongoing conversation about trying to look at the language of what the task force can do. And this is where we kind of came up with, how do we create press lists? How do we create a relationship with the press, et cetera? I think that I don't know if I have anything to really discuss about it tonight. I think sometimes we just sort of pass and leave it for the next month's meeting.
And I think we can do that tonight.
And although I don't want to exclude anyone from the discussion, but sometimes we just let it go and we go to the next month. I think at some point we'll be more agendized with it, like with specific proposals, but we're not really at that point yet. Yeah.
This question, are we looking at the roles of individual task force members or the task force as a whole?
Not individual sort of assigning people to do anything, more looking at things that could somehow be done, and then we just have to figure out, well, is there anyone who's willing to do it? That kind of thing. But we're not going to be, as far as I know, ordering anyone around. But it's more, like, how could we be doing more things better or more efficiently? And I'm not going to say anything about Doge here. But just, like I said, like the press thing is probably the most concrete idea we have right now. And we're just looking at all the powers that the task force has. And we're trying to figure out, are we actually sort of doing the things that really we sort of were envisioned to be doing or authorized to do. Yeah. So I think that's all we can really.
I think that.
Go ahead.
Well, no, I mean, I'm not gonna I was just mostly elaborating for Member Kumar. Like, when I joined the complaint committee, the big agendized change that came about not long after I joined was the introduction of the consent calendar, which at the time that I had joined the Sunshine Force was kind of on the tail end of a backlog that everyone was still trying to get through. And it felt as though at that time that the consent calendar, which I believe Chair Schmidt had tried to introduce, was it one or it was more than once before. But after having gotten that done, it enabled us to put forward our recommendations in a way that would potentially make it more efficient at the full board meeting. And so that's honestly how I view 6730, like this discussion item, which I'm glad that we have here. And if it wasn't this hour and it wasn't such a long calendar today, I would like to continue discussing in more detail, but I don't want to keep anybody. But I think the spirit of it really is sort of like that, where it's like, what can we do? Like, what policy matter can we move forward again to like make things more efficient or better?
Got it. Okay.
And the media list came about because, and again, now these are things that are all in recording, so but I feel as though we've all been interested in that, but I know that there are certain items that we have been discussing how we wanted them to have like a broader impact, or like, at least to have a greater exposure, and also the ability to educate a broader amount of the public on how Sunshine works as well. So it was more like the introduction was more of a question on, well, let's create a mailing list essentially.
Okay.
And I do think that, like, again, I'm happy to push it out another month for that discussion.
Yeah.
But like, but I do think that like we're still kind of just noodling around who should be on that list, how that list is being created. We should be able to wrap it up by next month, honestly, between us at least.
Possibly, yeah. We could come up with some kind of a set of like things that actually we came up with. I don't know if it's within the scope of this, but I know we just passed the was it 9 or 9:30 that we are
9
limited
o'clock,
to,
yeah.
rule, and that was sort of a new idea that I think we kind of talked about a little bit about in the.
We talked about it at the general meeting, and I do, of course. I was motivated with it. I still am. I would like to bring it up again at some point. But yeah, I think that the idea of making the general meetings more efficient in terms of their timeliness is a good way to go forward. Unfortunately, I feel like there's a lot of discussion around specific people and how often they talk and whatnot. And to me, I understand why that is. I also find I didn't want to approach it that way because I found it rather punitive to point it out. So it was more like how to hold our group mentality more accountable. But we'll see where we go.
This reminds me, I think it was a proposal that we cap the number of minutes each person gets to speak, like 2 minutes or 3 minutes, if I'm not mistaken. Is that also part of this?
That was part of the discussion.
Okay.
But that would require a lot of timekeeping for people. And also like, it depends. What's the 2 minutes? Does that mean that like it's 2 minutes per, is it like petitioner and respondent where it's like for that item? Is it 2 minutes per person for deliberation? Does it like, let's say I use 1 minute, does it carry over into the next one? Like there's all these questions that for me, I was just like, let's put something forward simple. Well, in the meetings at a certain time, and that'll be it. But it didn't quite get enough support.
I am not part of the complaint committee, but I really appreciate this item being on the agenda. It's a very necessary discussion.
Okay, yeah, and thank you for stepping up and helping us get this done tonight. Yeah, you're welcome to come back. We tried once, maybe we'll try.
It's usually a lighter caseload too. Yeah, but
yeah, it's usually like we haven't had this many cases in the last year or maybe 2 years. This was by far the longest complaint committee meeting we've ever had. So you got lucky.
Yeah.
Yes.
Happy to help.
3.5 hours. Yeah. We had the last one was 1 hour. 1 hour. Yeah. Yeah. 5:30 to 6:30. I remember that. Okay. Next item.
Public comment on item 10.
Yeah.
Anyone wishing to make public comment on item 10, please raise your hand in the app or press *3. I'll give you a moment. We have no hands raised.
Okay, next item.
Item number 11, announcements, comments, questions, and future agenda items by members of the complaint committee.
Nothing. I think we're good.
We have No public attendees.
Yeah, okay, so no public comment allowed.
Um, Item 12.
Yeah,
Item 12, adjournment.
move to adjourn.
The meeting is adjourned at 9:11 PM. Microphones are off.